we will file our reply in this case.
Again,
My lord,
Very
that
difficult.
I'm extremely sorry, my lord, there was inability of the official to finalize the draft, my lord. To obtain the consent of the other side, the petitioner's counsel.
we are appearing for
I'm appealing for some DF Employees Provident Fund Organization. To respond it.
let's see when the matter reaches.
Lordship, I will mention two petition for admission, posting of for admission.
What matter?
Matter pertains to, my lord, solemnizing of challenges and subsequent election of the, my lord, petitioner. Petitioner, my lord, obtain stay by suppressing all the material facts.
Evacuating.
Yes. No, for admission here. We have already filed our petition of admission.
Okay, 15th. Tomorrow. Two. When do you want? Tomorrow? Tomorrow? No urgency. Well, let us have it on 2nd of February. You file your reply. You file your reply, no.
Recently, they have filed one objection. I identified five.
Well, to be listed on 2nd of February.
Okay. At that mention, act number 5 to 9.
Huh?
Act number 5 to 9. Kindly allow us to withdraw those things. There are some mistakes that need to be corrected.
What mistake?
So many mistakes are there.
Huh?
So many mistakes are there.
What mistake?
Some errors are mistakenly.
We'll see when the matter is taken up, whether leave is to be granted or not. You want to withdraw, withdraw, no problem. Liberty, we'll have to consider the other side.
Get shortlisted my petition.
Which one?
It is 203 of 25. So it has not come up since 13 August.
Why?
I don't know.
What is the matter about?
Matter is regarding like ban on my firm. Ban on my firm.
Blacklisting.
Yes. Ban on my firm. So I cannot participate in the tender process. If you will give you Monday date.
Okay, Monday next, 8.
Democratically elected, town council member, madam.
Bench 5.
For appeal item 64. This matter is
Why? You got your money, Mr. A. Gosal appears on behalf of the petitioner and submits that the petitioner have already received the amount for which the petition has been filed. Mr. R. Gogoi appears on behalf of the PHE, for PHE. Taking into account the above, the petition stands closed.
65. Lordship, in this case, also we have received it.
Same.
For motion item 1. Only my lord, he put you punishment in place. That's only number 1, 2, and 4 is less. It is listed as
So withdraw and file it properly. You can't make them a party misplaced. No, nothing doing.
So in the meantime, the respondent authority verified 2 times, they have communicated last 26/11/25, they want to demand the fund,
Huh? Which department?
PH,
PHE. So withdraw. And file it again if you want to, but the contempt cannot happen like this. You have to intimate.
Well, already I have intimated, but the acknowledgement copy, I have displayed that, the petition are displayed.
So how can I help you? You see, I have to be prima facie satisfied, not on the basis of being misplaced. But
From 5.
you again take steps against this, fresh steps against whoever it is, and then file again. After, not after days, you have to, you wait for 3 months. Huh? What? So very good, there is no contempt. Wait for that.
Executive engineer Romeo. Here, the petitioner, 5 serial number.
So they have verified your amount to be 12,60,000
Yes.
and have therefore referred it to the additional chief engineer for demand.
After verification.
The learned counsel appearing on behalf of the petitioner submits that pursuant to filing of the instant contempt application, the petitioner have come to learn that the respondent authorities have the respondents in WPC number 1811/2022 have verified the entitlement of the petitioner to be rupees 12,60,000. And in that regard, the superintending engineer PHE on 26/11/2025 have submitted a demand to the additional chief engineer, a fund demand to the additional chief engineer PHE. The said communication has been placed before this court, which is kept on record and marked with the letter X. The learned counsel submits that taking into account that such development, the petitioner would not like to pursue the present contempt application for the time being. Would not like to pursue the present contempt application. However, in the circumstance that the said amount has not been paid within a particular span of time, the petitioner may be permitted to again approach this court. Taking into account the above aspects as submitted by the learned counsel for the petitioner, as well as the document which is kept on record and marked with the letter X, the instant contempt application stands closed. However, liberty is given to the petitioner to again approach in the circumstance the petitioner is not paid the demand and the dues. I think you need to file a writ later, not a contempt. Wait for some time.
Item 2, Time frame maybe given. Time frame will.
I can't give you any time now, because these are personal parties, no? Give me time.
In this case, after that, an infraction was solved of whether matter is proceeded or not by respondent number 3.
Why didn't you file an appeal? Why didn't you file an appeal?
But in case the district commissioner is the authorized person to take decision,
Doesn't an appeal lies?
no matter.
Why? Are you saying that the appeal lies, doesn't lie against the panchayat election? You are challenging the election of respondent number 7 and 8.
Under section 1112F and rule 46, rule 62 of Assam Panchayat Constitution, district commissioner is to take the decision.
No. Panchayat, madam,
District Commissioner is the authorized.
there is no appeal. An appeal lies to the district judge if I am not wrong. Some panchayat rules.
Kindly read rule 62. But matter relates to child marriage. Matter relates to child marriage.
Child marriage? What child marriage?
Child
We are
marriage.
concerned with, you have challenged the election
Yes,
of the respondent number 7 and 8. By whom?
by the defeated candidate.
Why the two defeated candidates are together?
Yes,
Why?
because one is one is from ward number 1 and another is from ward number 10.
My goodness. Then why didn't you get all the other people? Everybody has a different cause of action.
No, Lordship. The petition.
No, you see, the election of the petitioner number 1 is vis-a-vis the respondent number 7.
Yes,
Petition number 2 is vis-a-vis the respondent number 8. These are two different elections and one with petition. What is this type of election with petitions?
both of it is same.
Absolutely different. How can the cause of action be same? Would the petitioner contest in the place where the petitioner number 2 had contested? No. Then how can there be a cause of action being same? This type of cases doesn't have merit. Apart from that, elections, I think, where the panchayat election? Panchayat constitution, election. Election of what? Election of what
Ward
member?
member of the,
Huh?
ward member of the.
How can the writ lie against us? Because you have to challenge by way of an election petition. You cannot challenge by this. That is what I know. Yes. Not helping this. Yes, the government shall constitute such panchayat election tribunals as may be necessary on recommendation of the High Court to dispose of all direct election petitions challenging election under the Act. The jurisdiction, power and functions and headquarters of the tribunal shall be decided by the government in consultation with the High Court, except as provided in section 10. So, has there been constitution of the panchayat election tribunals? I think the district judge has been made.
Some time may be given, Mr. Brian.
I'm dismissing you on this.
Some
This-
time, and-
No. This is all
Okay, after 7, after 1 week, time.
after 1 week. First of all, it's a bench 5 matter. You got it before bench 4. That is another big problem you have done. Huh?
Two different courts, two different.
Yes, absolutely. You withdraw and file a fresh one. You cannot file it. Everybody has to have a different, but the question is whether you can file it, because you see, this is a question of fact which is to be decided in it. This is an election. An election, you don't come directly to the writ petition. You have to challenge by way of an election petition before the tribunal, and the tribunal happens to be, I think, the district judge, if I'm not wrong.
Under rule 62 of Assam Panchayat Constitution, and
Rule,
rule 62, 4A, B and C,
Rule 62,
4A, B and C. Assam Panchayat Constitution rules 1995.
62, 1.
4, 62, 4A, amended,
If the second child birth are twins, then,
62, 4.
2, 4, 4, 4.
Number 229 of-
Subject to the provisions of this act, at the time of filing of the candidate shall furnish affidavit regarding their age at the time of their marriage, failing which concerned heir shall be disqualified.
Then B and C.
No, Mr. Kamsar, everything is understood. You may have the best of the cases, but can this decided in a, by way of a writ petition? No.
My only. fear is
No, Mr. Counsel, it has to be done by way of an election petition. A challenge, a cancellation of a nomination or even a nomination, you have to challenge it.
I'm not disputing nomination, but
If you are not disputing the nomination, the matter is over. Matter is over.
also disqualification on the ground of child marriage.
That is also by way of a challenge, by way of an election petition.
We have filed a representation before district commissioner.
No, district commissioner has no business out there.
Kindly see.
No. District commissioner does not have any business.
Kindly see the team, my lord,
No. Any person who in connection with the so this.
Vice president or member of Nila Parishad, or member of Gaon Panchayat. If it is found that he or she or his spouse is under arrest at the time of.
I am not going to interfere with all these things in this, because this will have a far-reaching effect. Here, 129. Notwithstanding anything in this act, no election to any panchayat shall be called in question except by way of an election petition presented within 60 days from the date of the year to the tribunal constituted under 127. Madam, you are from panchayat, you don't know this. It is for me to find out. Sad. And here, you see, orders of the governor, panchayat tribunal are there. Madam, it is very sad. The PNRD department is not. Words are lacking. First, we are going to dismiss. Now, what do you want, how the dismissal should be? I leave it to your good wisdom.
Now time kindly.
No, no, time is not there. Time is, you have already spoiled the time of them also. They are looking into something which is not necessary. Without there being an election petition, how can it be there? Chalo,
I will. I will.
withdraw. Pure withdrawal.
Ownership, I will. Respect ownership, right? Current,
Fresh petition, that is also not permissible.
already 60 days.
Level.
60 days.
No, no, we dismiss both. And mind it, very interesting. Election was held when?
0205, 0705.
60 days is over. Finished.
Under section 1111 also, no, district commissioner is empowered. The panchayat. So we have filed representative for district commissioner to examine them.
Mr. Counsel, what is your good name? When you are challenging an election, you have to know how election petitions are, how elections can be challenged. You don't come and file a writ petition. You are lucky enough that the earlier judge who was taking it was kind enough to issue a notice. I'm not going to issue a notice in this case. Forget about notice. Luckily, notice has not been issued. How can you have these people have already been elected? See? Bad day, a sad day. Anything, madam? Any further wisdom you want to throw? This side. But madam, this should have been your submission. In view of section 129, there is a complete bar. We now may, the wisdom which you are throwing is the B. They are not that deputy commissioner. Level. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. N. Bora appears on behalf of the PNRD department. Ms. U. Das, the learned additional senior government advocate, appears on behalf of the district administration. The present petition has been filed challenging the election of the present petition has been filed by two petitioners challenging the respective elections of challenging the election of the respondent number 7 and 8 to the present petition. It is being submitted at the bar that the election that respondent number 7 and 8 were elected on 5/7/2025 in the respondent number 7 was elected to ward number 1 under the what Gaon Panchayat
Ward number 1.
of
45 numbers, Sonapur, Ruby.
45 number Sonapur Ruby Gaon Panchayat, and respondent number 8 was elected
Ward number
to ward number
10.
3,
10.
10 of 45 number Sonapur Ruby Gaon Panchayat, Fusto. First and foremost, the filing of one single writ petition challenging the election of separate elections of the respondent number 7 and 8 is not permissible. Secondly, this court takes note of section 129 of the Assam Panchayat Act 1994. A perusal of the said provision categorically mentions at clause B of section 129 that no election to any panchayat shall be called in questions except by an election petition presented within 60 days from the date of declaration of the election results to the tribunal constituted under section 127 of the Act of 1994. Under such circumstances, it is therefore the opinion of this court that the instant writ petition is not maintainable. Further to that, this court further takes note of that in terms with section 127 of the Act of 1994, the governor of Assam, upon recommendation of the Guwahati High Court, have constituted the panchayat election tribunals by the notification dated 4/10/2025. Considering the above, the said notification is kept on record and marked with the letter X. Considering the above, the instant writ petition, therefore, stands dismissed. You file the election petition by tomorrow. Today is what? 3rd, na? File it by tomorrow. There. You still have time because it was done on 4/10. So 4/12, you have time. Today is 3rd or 4th. How? The tribunal was constituted on 4/10. So you have to file it before the tribunal. When is it? 2 months will be over. There can be no more spoon feeding, Mr. Counsel. Yes, Mr. Deka, what is this? Your license have been cancelled.
Yes, sir.
Why?
But there, the only that I have not maintained is for base the quartermaster, I am but this is not the correct factor.
What is your ground?
Ground is the, why we have maintained the report and they might be supplying the lights to the company.
Huh?
We have maintained the EPOS message, electronic pointer message,
Ah,
for those 2 months. We maintain record, it is reflected from the update line.
no, this is against the suspension.
No cancellation order.
Where is the cancellation?
Cancellation order was final page number 46 or 22/1/24. Thereafter, we prepared appeal also and appeal also.
So unless there is a procedural lapse, I can't touch it.
Yes, also because they have not funded the hearing of the inquiry report. And the.
What inquiry?
The outcome before also tagging our thereby stop loss.
Hmm.
We have not been starting this over.
Where?
Tagging order was built by the page 14.
When was it cancelled?
Cancel up to 22/1.
36/2025.
Page number 46.
What is your appeal file?
Appeal file immediately thereafter.
What is your ground of appeal?
Appeal lawsuit, we are thinking that we have not been.
Where is your ground, a memo of appeal?
Annexure 7 to the memo.
Where is your ground? Without serving any so-called notice?
So for this, prior to the cancellation of our campus of license.
Are you sure that there is no so-called notice?
Thereafter also they issue.
Then matter goes for a 610. Upon the appellant only after suspension and taking of the money for 1 month, the appellant collected food grains from so and so an allegation leveled against the I am not here. While the inquiry was conducted, the appellant was not heard in inquiry report and others that are not furnished to the appellant to prepare his reply before issuance of the impugned order. Okay. Now, what do they say about the inquiry report?
They have randomly collected documents, Lordship. So Lordship kindly come to the page number 32. In respect of the petitioner, Lordship.
Oh, you have not been looked into this. Madam, this was a specific ground taken at page 54, 15B.
It's impacting the issue of it.
Where's your reply? Huh?
The reply, I got, but I.
Then, did you raise that issue about the inquiry report you wanted? Did you raise the issue? Then look here, I want the inquiry report on the basis of which you have got all these things.
Lordship, this is not, I am here, because the petitioner put down what is submit the reply, so I am asking them. Yeah, technically, similarly, you must write, you know, we have provided all the.
What?
And they like a similar case. I am to get without file this with this. Since Lordship, there is a defined cause of action, so we separately file it about that. Will not good.
Notice was issued
Yes, yes.
only.
Then cancellation order, same as, you know. Paragraph number 8 and 9.
What happened on 112?
One to also they trying to get in front. Yes, similar.
He put the steps late.
Ah, yes, yes, I fixed it on 26/1, isn't it?
The steps have been taken, but it was
Ah, remember. Ah, they have not taken steps. He, Mr. Deka did not appear, some junior appeared.
taken.
I'll take that.
2011,
No,
taken.
Madam, only point he has is 15B. If you are relying upon an inquiry report in your original order, it was required that incumbent upon you to furnish him the inquiry report. Because your show cause also, that is why the problem is you have to get, I would have otherwise allowed his repetition today. But and you did not maintain the stock register and sale register as per the inquiry report, page 9, dated 9/3/2022,
This is one of
page
the-
44. So therefore, if that be so, he should have been furnished with that. But that aspect which he raised in the appeal was not considered by the appellate authority. So,
And
but the only thing is, you will have the records.
after filing this, I think we filed the RTI. Whether we have maintained the record or not, but they have supplied the report. On the report, it is reflected that the page, annexure 9, page 63, this is the RTI report. And for the month of July and August.
The report of the distribution for the rise of so and so is included. The matter has been handed over to the police for further investigation and so and so. What is that? No, this can't be the report. The report is the ministerial inquiry report.
Regarding the distribution of rights, regarding their specific cases that for the month of July 2022 and August 2022, the petitioner has not maintained the stock rates. That is the ground. But so far, my terms are assumed we have maintained this or distributed this rights to maintain the EPOS machine. EPOS machine is the electronic transfer scale. So that is the report from page 64 onwards. If you kindly come to page 64, so for the petitioner is concerned, the
Page?
last one, page 64, the RTA report. In my sample project, there are altogether 70.
What is the name of the petitioner?
Their name is not given, it's a Losanabari. Majida Khatun, but his shop name is, the last one, Losanabari Samawai Smith.
Where?
The page 64,
Ah,
last name Lordship.
Losunabari, Bahumukhi.
Pratham kindly see the total cards, 77,
Hmm.
very cards.
No, that is a different thing,
That
Mr.
is
Council,
the-
I am not on that. Those things I'm not going to look into. Your case would be on the basis of that report. You see, here, kindly see this particular page 46. Page 46, the fifth paragraph. Whereas the inquiry report revealed by so-and-so has diverted illegally the rice under PUF for the month of so-and-so from targeted AI into black market and so-and-so. So this is an inquiry report. If it is so, if you are basing your order on the basis of this, you have to furnish it to him. In fact, that is not even the subject matter of your show cause. So that is why I wanted to allow his petition, but he wants a notice. Let us issue a notice.
This was not on that aspect.
What about that inquiry report? It is not there in the show cause notice. Show cause notice should mention that now when you are taking that. Where is that inquiry? Kindly see page 44. They say about some other inquiry. You have not given the proper copy also. See, he wants a notice. This report, 3/12/2022. Did you provide him that report? Hello. It is Mr. Order at a DD notice returnable on 26 one, na?
I will take it. I will provide it. I will write it.
ডেটটো কালি পুৱাই যোৱাকালি নে পৰহি আছিলে এই কেছটো এই যোনটো ডেট আছে তাৰ লগত মিলে একে অৰ্ডাৰ He had a good case, but he wants to notice
I can go. Everything.
10 also similar. Same day, all these. Oh, these are 5 writ petitioners, na? Ah, 5 writ petitioners. I allowed one. Yes, I remember.
I can post.
10 to AKU. Yes, Mr. G.G. Gogoi, what is your case?
Against the fixed deposit applicants are to Government of the on 17 numbers of with the absolute certificate of this 10,000 and one factor of 10,000. On 8/8/2017, the people submitted an application before the branch manager to withdraw the amount. But the restaurant did not pay any that is not. And having not out in the I told the product. Is the consumer.
So you want the execution of the award passed by the District Consumer Redressal Forum?
Yes, sir.
Isn't there avenue available there? As per the Consumer Protection Act?
Already some notice on something winding up.
Who?
Respondent number 4 already winding up. And the respondent.
No, understood. Everything is understood. But the Consumer Forum is taking up the matter. Are you saying that the Consumer Protection Act doesn't provide avenues? There are avenues available.
Already give a direction, pay the same.
The case will be disposed of here.
So
On 3rd of May,
May.
March 2023, the case will be consumer it is a promise, give the direction, the respondents.
Understood. When there is a direction, there is also a mode by which you can execute. Why you're not there? Why you may approach this court?
Already one thing happens, responding appoint the liquidator at the power is to liquidator. The officer medicinal.
Huh?
Page 66, my lord. The officer of excellence already completed officer of management, Akam Bhagavati Samvaya Samiti.
So this is already given. Why should this court pass any further direction? No, you see, there is already a forum looking into it. I have looked into it, and you have a further forum. What is the direction given?
Relevant.
Page 59.
Page
59. That
1,75,000.
yes, sir. Principal amount.
And thereupon, you have already issued that notice.
Yes, sir.
So there, the district consumer forum is taking up the action. Why should this court interfere again?
But they have not paid any amount.
Who?
The respondent of petition.
This one number?
Till now, they have not paid any amount, the respondent number 4 and 5. And
Understood. Respond number 4 and 5. So it is a dispute between you and the respond number 4 and 5. So the officer, that particular cooperative society is under some officer. So the officer has to look into it. You are looking into it.
Page 66, madam.
Yes, he's looking into it. Why should this court further interfere? District Consumer Forum will do it. No, this is not a case for no fish. See, 27. Section 27 of this act. My goodness, Mr. Counsel, you appear before the court without the act also. Hey, when did you? Look here. Because if we take any action out here, notice I cannot compel 4 and 5 to pay. I can only ask the officer in management. Now the officer in management is already taking steps. Why you are not initiating this under 27?
they have, only the respondent number 2 issued an office to the respondent number 3. Page 66.
No, understood. That is the officer in management. You have to get 2,22,000 or something. Now the question is, how do you get it? The cooperative society is under liquidation. If it is liquidation, then it will follow the rule as to who will get the first amount. I cannot direct anything out there. When it is under liquidation, your claim will be duly taken note of there. First, the payment will go towards payment made liable to be made to the laborers, the workmen. Second, it will have the third creditors. You are a secured creditor at best, nothing more than that. So there is a manner in which it is to be looked into. See the Companies Act. Our Corporate Societies Act may have the similar. This is the manner in which it will be looked into. So it will be there. If I issue a writ, am I not passing an order, thereby changing this chronology of in which the payment is to be made? That case, go there.
What do you mean?
What liberty? You are already there. No liberty business out here. You are already there, na? Because you see the order which has been passed, kindly see this one, page 61, appears to have been passed by the District Consumer Forum pursuant to the order. So therefore, the District Consumer Forum is already looking into it.
I respond to the respondent, but the respondent point I want, they, now they have no power.
Who?
Respondent point I.
Respond number 4 and 5 has no power, but respond number 3 is the official liquidator, before whom you have to go and make that claim. You come within the ambit of a secured creditor, and as such, your claim will be accordingly looked into. Now, out of 2,25,000, you may get 10,000 also, depending on how much money is left.
So I have only, submitted an application on 64 only. Liquid.
Withdraw. Enough of wisdom in the morning for 2 advocates. No more. Mr. So-and-so, the learned counsel appearing on behalf, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Ms. So-and-so, who appears on behalf of the corporation department. The learned counsel appearing on behalf of the petitioner submits that as the District Consumer Disputes Redressal Commission, Lakhimpur, not Lakhimpur, is already taking steps in pursuance to the judgment order dated 3/3/2023 in CP case number 2/18, isn't it? Comma. The petitioner herein would not like to further pursue the instant writ petition. Rather, if necessary, the petitioner would invoke the provision of Section 27 of the Consumer Protection Act 1986, if so required. Taking into account the above, the writ petition stands closed. The closure of the instant writ petition shall not, however, prejudice the petitioner in any further proceedings, initiated for compliance with the order dated 3/3/2023 in CP number 2/2020.
Public.
5.
Yeah, reference dispute. What is this defect? What is this defect? Filing form not filled up, petition not indexed, no court fee stamp fixed, so and so. This was filed in 2023. You have come before this court now. No. We dismiss it on the ground of non-compliance. Withdraw. If you want to withdraw, withdraw. But nothing more than that. No liberty. No liberty. No liberty business. Otherwise, the cost of 1 lakh each. You are challenging certain things. You cannot keep this matter. This is of order of 2022. You want a liberty, but no limitation. The question, you have not corrected this thing for the last 3 years. So, why should I give you a liberty? And then you file it and say that the court has granted the liberty. I'll give you the liberty, but this is, I'm making a categorical observation that this is a case of delay or laches. Yes, Mr. Who is there for central government? Type of cases, na? I know what is your reason why you are doing it now, withdrawing it. You're challenging an order. Passed by the. Where is Mr. B. Gogoi? Finance? CGST, who is he? Oh, yes, you are there. What is this? What do you have to say?
Finance.
Huh? No, they have intentionally not filled up the form. देखो, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Putikpate Sailu, huh? And Miss So-and-so, you are from say, CGST? Oh, no. Okay, none appears on behalf of the CGST on call. The petitioner herein has approached this court challenging the show cause notice dated 22/7/2022 issued by the Deputy / Assistant Commissioner of CGST and CE Bongaigaon Division, Dhubri. Full stop. It is relevant to take note of. Now today, when the matter, it is relevant to take note of that the writ petition was filed on 6/1/2023. Full stop. The record further reveals that on various occasions the petitioner were given the opportunity to make corrections, but the petitioner did not do so. The defects which remained in the said application, in the writ petition, were number A, filing form not filled up. Number B, petition not indexed. Number C, no court fee stamp affixed. Number D, no paras filled up in the affidavit. This court further takes note of the affidavit which have been filed to verify the contents of the writ petition. And the said affidavit under no circumstances can be said to be an affidavit. And it really surprises this court as to how the notary public had affixed its stamp over such an affidavit where there is no where paragraph 2 has been kept blank. Considering the above, it therefore appears that the petitioner has not been diligent in the instant proceedings, and the writ petition was just filed for the sake of filing. Today, when the matter is listed, Mr. So-and-so, appearing on behalf of the petitioner, seeks the liberty to withdraw, taking into account with the wants to withdraw the writ petition with the liberty to refile. Considering the manner in which the petitioner has filed the instant writ petition, liberty, the instant writ petition, taking into account the said fact, the writ petition stands closed on withdrawal. However, this court declines the liberty in view of the fact that an equitable jurisdiction of this court had been invoked by a litigant who is not at all diligent. 4 to 5 to 9, all. No. Or pay 1 lakh. If it was a final order, I would have. You are challenging a show cause. Show cause has this way. Sorry, unhelp it. All these matters goes. Next.
11.
Where is Miss D Ghosh? Who is appearing? D voter.
But here something different is something different. Already offense pending motion. There is already offense, yes. Yes, it's mentioned in paragraph 18, page 14, paragraph 18.
Page
14, paragraph 18. In the FT case. What is the outcome of?
Prisoner lastly only have visited the office of the and submitted the paragraph.
18, page 14.
So is the FT case pending?
That is not really important because what is the outcome of this case? This was not important.
Yes, what is the case? What happened to the FT case?
No reference, very.
What?
Reference is not against me.
Paragraph 18, you say that there is a reference pending at Guwahati.
Yes, pending, but notice is not signed.
Oh, very well. So after the notice is over, then only you will be out. No, no. FT pending. So if it is pending, nothing can be done. You say that the FT is pending. So how can I remove the D? Taking into all my other earlier orders. All my earlier orders, I say that look here, I am not in a position to decide as to whether to remove D or not. So if there is no FT case being registered, so therefore directing the SP boarder to register it. And if it has already been registered, to inform the petitioner that the registration has been taken place. Now you say that there is an FT case. So how can I remove it? Matter over. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appears on so-and-so, and so-and-so, so-and-so. Pusto. The petitioner herein is aggrieved. How many petitioners? The petitioner herein is aggrieved by the fact that the petitioner name has been against the petitioner's name in the electoral roll. Electoral roll. Where is that electoral roll? Huh?
Page number 45.
Electoral roll is number. Electoral roll page number. Where?
Page 45.
Where's the D?
D is on first, 589. Here now. So join the D. $10, sorry.
Against the now what is this page 44? In 2010 it is okay. But 2011 it has been marked. It is the case of the petitioner that the petitioner is a voter of 39 number Joleswar Legislative Assembly. Pusto. The petitioners in the year 2000, in the electoral rolls of the year 2011, a D was marked against the name of the petitioner. And the same name continues till date. Pusto. It is the grievance of the petitioner that the same name, that the remark D should be removed from against the name of the petitioner in the electoral roll. It is relevant to take note of that at paragraph number 18 of the petition, the petitioner has duly mentioned that an FT case number 205/2018 have been registered against the petitioner at Guwahati, Kamrup Metro, Assam. He therefore submitted. However, it is also the stand as submitted by the learned counsel appearing on behalf of the petitioner that no notice have been received by the petitioner in respect to the said FT case number 205/2018. Full stop. Considering the fact that there is already an FT case being so and so registered against the petitioner, and it is only the foreigners tribunal who can decide as to whether the petitioner is a citizen of India or not, comma. This court, therefore, this observes that, and it is therefore the opinion of this court that the present writ petition, that no orders can be passed in the present writ petition. No directions can be passed in the present writ petition, thereby directing the respondent authorities to remove the name, the remark D against the name of the petitioner till the FT case number so and so is resolved. Full stop. The petitioner, however, it is this court, however, is of the opinion, is also of the view that the petitioner should be intimated as to in which tribunal, in which foreigners tribunal the said FT case is pending, so that the petitioner can put in its appearance. Accordingly, this court therefore grants the liberty to the petitioner to approach the superintendent of police border, Guwahati, huh? DCP border, Guwahati, Guwahati. That is the respondent number.
It's, but it should be here, the police, Walpara, yes, the main part.
To the DCP border, Guwahati, who shall duly intimate the petitioner along with a certified copy of the instant order, and the said officials shall duly intimate the petitioner wherein the FT case number so and so is pending. With the above, the petition stands.
Well,
Yes, Mr. Siddharth. What is this Munsif doing here?
my lord, tell on the particular situation to healthcare.
Huh?
That if he was given in respect of land covered by number 170. But forcefully wrongly executed in my land, my lord, is covered by Pata number 179.
Mr. Siddharth, I know that in bench one, you had a lot of battles before this court. So I also know that you know what is the requirement. If you have been dispossessed, wouldn't that the provision of Order 21, Rule 99 apply? How can a writ be filed?
Well, see, the party has not declared appeal, my lord.
Not necessary. In an execution,
My lord.
in an execution proceedings, if a wrong plot of land has been taken over,
Right.
execution, there is a problem. Doesn't the mandate of section 47 read with order 21 rule 98 would come into fit? You have the CPC. CPC.
Right.
Open it. Order 21 rule 98. 98.
Order for after change. After the determination to question refer to rule 100 make an order very carefully and directing that the applicant be in possession of the property of us or other order has.
No. 99. Where any person other than the judgment debtor is dispossessed of an immovable property by the holder of a decree for possession of such property, or where such property has been sold in execution by the purchaser thereof, he may make an application to the court complaining of such dispossession. So
He has filed petition.
then there it will be done.
That has not been, that has been discussed.
Then if it is dismissed, then wouldn't it come under the provision of order 21 rule 102? It will be a decree. If it is a decree, wouldn't then you have to file an appeal under section 96? You know all these things. Withdraw.
Well, I have make an observation.
Mr. Sikdar, I don't hold the advisory jurisdiction. It is only for the Supreme Court under 143. I can say that this is your submission and I agree to it.
Yes.
Then it looks better.
Right.
You were not a respondent, na?
Well, we were in this, we were dependent.
Huh?
In suit, we are dependent. With at least 21. We were dependent. It is number one, the wife of criminal number one. And three, four are already.
What is your name? Mr. Sikdar.
My lord,
I think
I'm
you
the wife.
I would
of
not
criminal number one.
I would not like to further comment. I think you should withdraw. You have approached this court earlier under 115 or 227 against the order passed under section 47, that is order 21 rule 99. This court had dismissed your application, holding that it was proper, which this court ought not to have done, taking into account that there was an appeal. It should have gone to the appeal, but this court took up and dismissed your application. How on earth can this court, under 226, exercise jurisdiction? It has attained finality. This very issue which you are raising in the petition is there. See, the order passed by, this is Robin Fukon, page 101. I would not say anything, withdraw. But Mr. Sikdar, you are a senior, very senior at the bar, so I think you should advise your client not to do all these things. This type of petition, if it was I on a bad mood day, then it would have entailed huge cost, including referring the filing counsel to the bar council. Be careful. Today I'm in a very good mood. Vacations are coming. Mr. A.R. Sikdar, the learned counsel, A.R. Sikdar, the learned counsel, appearing on behalf of the petitioner, submits that in view of the order dated 21/7/2025, passed in CRP number 94/2025 by the learned coordinate bench of this court, the petitioner ought not to have approached this court under Article 2 to 6 of the Constitution. He therefore submits that the petitioner would be well advised to withdraw the writ petition. Accordingly, the writ petition stands closed on withdrawal. What is this non-payment? They are not getting a non-payment. That is what I was thinking. How old is the matter?
It was made on 21. 18 to 20.
I give the liberty of 4 years. Look. Outstanding 2977. As per the RTI certificate. 17th February, 10th, yeah, replied by 10th.
40.
Yes, Mr. Sheikh. Devoter, what is this? Devoter, simple case. Chalo, disposed. Give the day, you have put the. What is this, madam? Non-payment 1718. Completed against the work completed by him in the year 2020. Where is the completion certificate? Any admission that the work was completed in the year 2020? Okay. This is an admission in there. You are claiming for 13,37,000. Notice 17/10 February. You accept notice for all? Yeah, there is an admission by there is a signature of the chief engineer. So have a look at it. All give your names. Well, water resource. This is water resource. And madam, your main page is getting torn out. Be careful. Hey, Kanti Kuru. This is a hard trump card. Okay, 9 February, you can file your reply. Okay, 9 February. 9 February. Yes, and you file your reply by 2nd of February. Okay. All of it. Both the matters.
May I speak, my lord, regarding item number is 14. What happened, my lord, in here
Item number 14.
is. The first page, my lord, name was wrongly typed.
What? I am not concerned with the wrong typing of the name in the page. Whether it has been a wrong typing out there in the CIS. CIS is a very difficult thing. Put into some. And Mr. Sheikh,
Register, not looking into the first title matter, in the synopsis matter, there is a wrong title.
where?
Wrong name has been put in the synopsis. That has been reported at the.
No, I'm not on that.
Yes.
Whether the name has been rightly put out there.
It is written as Dewan Akbarati, but name is Dewan Kishore.
So in the CIS, whatever it is,
Dewan Akbarali is also a decoder. So page number 20.
Dewan Akbarati is not the petitioner.
huh?
It's only time.
What is your name?
My name is Dewan Yusuf Ali. Second page from first title.
Where's the Diwan?
Dewan Yusuf Ali.
Your name is Yusuf Ali. Why you are putting the Diwan business out there?
One in
What title?
for Rashid, at page 2 of my petition. Dewan Yusuf Ali. First title.
You have, you'll have,
Not.
Dewan Akbarali.
One
Huh?
copy reference start upon this Dewan Akbarali. The copy reference start. Yeah, everywhere Dewan Akbarali.
by hand you have done it or what? This page was changed later on.
Is wrong typing at the first page.
No.
Your Rashid will see my petition.
Mr. Sheikh, listen. No, Mr. Sheikh, listen. Did you give them a copy which says Diwan Akbarali?
That I checked, my lord.
No, you don't take it. You can, don't do it like this.
No, my lord, if there is
There must be somewhere some mistake. This page must have been changed later on. Second copy do some.
wrong copy has been given.
Wrong
It is
copy
wrong.
there that. Have you filed it for Akbar Ali?
Yes, I filed for Yusuf Ali.
You're going to Yusuf
Akbar is earlier.
in a synopsis.
It is wrong.
Okay, you do one thing. You just we'll have it at 2. Restrict to CIS of CIS. If it is in CIS referred as Diwan Yusuf Ali, Yusuf Ali. Otherwise, we may have to ask the CIS to be correct in that order. So let us first find out whether it is Yusuf Ali or Akbar Ali. Okay. 2.
All that is for granted. In view of whether the petition is at 7/4/2025, by the excise person. The people that have applied for conversion, I have an obligation of at least to I have the order. The legal rules here also been by the 2016. Very common. Recommendation was also sent by the district commissioner. Was it, the decision is pending.
What is your right? Conversion?
That means
Page?
my hunting strong is. The amendment has been made on. 279A. Says that after publication of the gazetted. 3 days of the publication of the gazetted.
You were granted where? Mr. Council, where are your applications?
If we start from page 18. That's of the page. 31.
Hmm?
From page 18.
How will, rule 279A come into picture?
Page 16 you also.
Huh?
Page 16.
Yes, which one?
Page 16.
Page 16, which rule?
Section 79A, serial number 13.
279?
A.
That is for rural area. Now you see your certificate at page 21, it is urban area. What do you say, Mr. Gogoi?
But it will be this is urban in nature. The rule says conversion will be done only in rural areas.
No right. No read. Better approach them,
Then already approached them, but no.
pursue, pursue, then to get an order from this point. Because if I say something, it will be dismissed. Rejected. So you better withdraw. Mr. So-and-so, the learned, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. R.R. Bala, R.R. Gogoi appears on behalf of the Excise Department. The learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to approach the respondent authorities, then to pursue the instant proceedings, taking into account the above, the petition stands closed on withdrawal. So the withdrawal of the instant petition shall not, however, prejudice the petitioner to approach the respondent. Same. So this very minute thing you did not notice.
Activity item 66.
Metro Boston. Second round of application by all area, order is by the sales 17. The only basis by the hearing is concluded. Would be a person I failed to appear, I not, I stand by the that's up to the law. Only question by the hearing is concluded, sometimes because already there. That has been done. In terms of the order dated, by the 8/4/24.
Friday. I will verbally inform that in between, the petitioner was called for hearing, he did not attend. The petitioner was called for hearing of this matter, but did not attend. The written instruction and there is that Friday or other. Further, Mohan period is already over. Your Lordship. This Mohan period is already over.
So that is what, not a simple virus, so on, we could expect it, because of the often created by the authority. We have deposited about 10 lakhs of this today.
Where is the earlier order? Which was set aside?
Page 70, man.
Huh?
Already part in page 72 euros.
So this order is no longer there. This order is no longer there. Page 67.
Page 67. Yes, it is already set.
So this is no longer there.
Yeah.
Now, what is your claim?
Now my claim part of the hearing is to be, it must is logical end. It should end is the logical end.
Now, what do you want?
Why was my the hearing date maybe fix anything, I will hear my lord, that be convenient. If the hearing, whatever will the result, let them decide, then law will take it.
So why do you want a similar order of this type? Means that order of 19/6/2021
Minus page
is an
74.
order by which the court had set aside on the ground of failure to comply with the principles of natural justice.
Right.
So that has been set aside.
Right.
And thereby giving them another chance of hearing.
Yeah.
If they don't take any action in that regard, your consequential action is as to whether you are entitled for running.
So I am not at this stage, my lord. At this I am only for the hearing, my.
So why do you want the hearing? Because this order is against you.
Page 74, my lord, and it was given, page 74. But in one occasion, I had some problem, I could not go, I said, I want to present it, that is not allowed. I had also some problem, my lord, I had so one thing I could not go.
So you could not go there.
Right, fine. I
Then
had-
what happened?
Page 84.
So you want another date of hearing?
Only my any days committed to them and to me.
Oh,
I let them
Silkovich.
conduct the hearing.
What do you say?
Fact between, he was called for some hearing on option and he added a few that still remain inconclusive in option. So let the matter dispose of, fixing a time frame for the hearing and taking this. If only he explains that much.
No, he wants another opportunity of hearing,
Yes.
nothing more than that. The question is, on the particular dated on 14/7/2025, he could not participate. And thereupon, there is no order passed. Has there any order been
No,
passed?
that remains inconclusive. The hearing remains inconclusive.
Inconclusive. So are you thinking of giving him an opportunity of hearing?
Question.
So get your instruction at 2. And if you want, we will pass an order to the effect that he will appear on such and such date and matter.
That is whenever you must fix a date, then if I fail, what I have to.
I don't want to fix a time period. Why should I fix a time period? But I want to give him an opportunity of hearing. Because if I fix a time period, it will go against you. Because you can't get an extension. Problem arises there is there. You can't get an extension. So you can't get an extension. What is the only thing is, the question is whether they are going to blacklist you or not. Why do you want that order in your face early?
I don't know what I had not really watched it.
You get an instruction. at 2.
But I may not even present you. Okay, cool. So that's true.
67.
What is this, Mr. Hawk? You have the mining lease. You have the mining lease. Huh?
No, my lord, I have got my fees, my lord, in the NIT card,
NIT for?
for settlement of send.
Very well. So therefore I'm asking you, do you have the mining lease? And my mining permit?
Really, I have, my lord.
Have you got the mining permit? What is the mining permit or what is that? You have to get it from the environmental mining plan.
Yes.
Where's your mining plan?
There was my lord. My lord, picture,
No, Mr. Hawk, you are asking this court to pass certain directions to give it to you, hand over the area to you. But isn't it required that you have to have a mining plan?
Of course,
I did not annect that matter. Because the tender committee had already settled the issue. Only thing is that one ballot, a meeting, ballot member, the EPL, that directed the additional influence upon the forest to settle, that send one to other member. We got people participating in the tender.
What is Annexure G?
But this is the regular communication issued by one executive member of PDC.
Your name is not here.
I heard.
Your name is not here.
No, madam. This 2% matter, they again another change there matter. There are two send more matter. Send more number 12 and 13 matter. Well, what he had done, well, he had created the additional sequence of forest matter to settle those two send more to this person matter. These 2% had never participated in the field. You will also kindly see whether they are competing. with different matter.
But that was on 12/11.
Yes.
But on 13/11, they have approval for comparative shortage has been given in your favor.
But they are not matter, they are not matter. They are not its.
May I pray, Master? Here it is this moment proper the amendment is been brought. In 2018, there's pre-tendering. But this is not pre-tendering. And so, my lord, there are certain orders which are by this or regard to that. So that everything is transparent. So 34 rules, has been subject to amendment. And in 2008, everything has to be by them. Not with that here. So they are speaking order from this honorable court itself that all tendering has to be by e-tender. So the decision has to be taken. If we fix on 8 pilot, I'll be the expected. But
The intent, in the legislation 18, 25, 25, 2025. And that seems, Secretary of the PTC has also approved.
I understand. Your case is this, there was a notice inviting tender being done.
Right.
Now, in view of Rule 34, na,
Yes.
it is the mandate of law that it has to be only by way of e-tender, e-auction.
Very that's.
The sad part about life is this. This happened because of an action taken by the BTC, whereby there was one notice inviting tender published in a proper newspaper. And there was one notice inviting tender issued only in 6 copies of a newspaper. And in the original copy, actual copy of that newspaper, a Boro paper, there was no tender. So Mr. Das, who is sitting behind you, he came up with a repetition with 2 showing his thing. And the other side was appeared by Mr. Espora as well as Mr. J. Ahmed contested that look here, this is the tender notice where it is there. It so happened, it just came to my mind about that newspaper act, no? There's a newspaper act which required that when you publish, you have to give it to some persons, some authorities. So I asked them that you must have given it. So they said, yes, to whom? So we give it to the director of publication of Boroland, BTC, as well as SAM, as well as we give it to the Legislative Assembly. All these things they say. I then directed the director of publication out here in Assam to produce that newspaper. So he produced that newspaper which did not have the text. And that is why it is now the mandate of the law that they have to go for an e-tender. And in fact, if you read Rule 34, it categorically mentions 1 and 2.
Yes.
2 says only by e-tender. That is why they have done.
Already.
Compensation, civil code,
The recently matter, should have taken care of that matter.
understood. So compensation, civil court.
Immediately I can report complaint.
Definitely you should go.
My lord, another action of explanation, sir. That was there was the executive member, my lord. Yes, created the additional forest member to settle that fruit. My lord, may have other person. my lord.
Anyways, I'll issue a short notice
Well,
which will give you some satisfaction that you have filed a writ petition.
my lord.
No stay, nothing. And on
Yes. Oh,
Monday,
But
he will come up with that instruction that the problem is because of that order passed by me with a claim finality. They have now to go for it. And that will be then put it and then we close your chapter. Only thing is now you may have to, your client may have to spend some money in steps. The fact remains the same. Issue notice making it returnable on 8th of December 2025. Mr. A.K. Bhuya, the learned senior standing counsel of the BTC, accepts notice on behalf of the respondent numbers 1, 2, 3, 1, 2, and 4, 1, 2, and 3, and 4. Extra copies of the writ petition be furnished to him during the course of the day. The grievance of the petitioner for which the present writ petition has been filed is that in pursuance to a notice inviting tender dated 25/8/2025, the petitioner submitted the bid along with two other bidders. Two other bidders. In respect to Bornodi Sanmohan number 13. Full stop. The bid of the petitioner was found to be the highest. And also compliant with the tender notice. It was also recommended that the petitioners be it was also recommended by the secretary BTC that the petitioner should be granted the mining contract in respect to Bornodi Sanmohan number 13. It is the case of the petitioner that though such recommendations were made on 13/11/2025, but on account of a communication issued by the executive officer, Bodoland Territorial Council, there's a move to cancel the entire tender process in order to accommodate two persons. Full stop. The Mr. A.K. Bhuya, the learned senior standing counsel of the BTC, submitted that the reason for going there is a move for cancellation of the tender process in view of the fact that the said tender with notice inviting tender was not issued in terms with Rule 34 of the Assam Mines and Minor Minerals Concession Rules 2003. 13. He, however, submitted he will produce the instructions on the next date. So taking into account the above, list accordingly.
39 same or only 39.
39.
69, sir. No, 69, my lord, it is again the package number 12.
Hello, at the 13 at the 12.
Okay, 69.
What is this?
I have shown this late, but this is under subsidy by this one. In respect of other people.
Oh, yes.
Yes, now, my lord, why I came before that.
Whenever I fix the matter, the other one, where I have raised a very important issue.
My lord, one more important issue.
Are you one of the other bidders?
No, what inspired me
to come, I want the word expired of 21/11. Because 9/10/2025 there was an order where my lord, it's not proper to use the word misled. OHSAS, your lordship, there's shown me wrong. This has, I will now demonstrate, this absolutely has become obsolete. Obsolete. Now, OHSMS, which in one day I got this certificate. When I tried to get, we could not find out where is OHSAS. And your lordship will kindly see, this has become absolutely obsolete. And your lordship observation is that the learned is allowed and the court has allowed. Why Article 14? Well, we could have also got a chance of it. Sanctity of the entire selection is being questioned now. Sanctity of the, is it?
In fact, they are also questioning it, isn't? Are you not also questioning it? The very sanctity of the technical evaluation which was done, wherein out of so many bidders, only 2 were found to be
Three.
Two
Out
or
of
three. No,
23.
3 or 2. 2.
Three.
3 were found to be technical out of 20. Now, by dint of an order passed by the learned coordinate bench, the 4th came in.
Yes.
Whereas there were other 16 tenders who were a bit similarly situated. Either allow everybody or don't allow anybody.
That was allowed by the order of this honorable court.
Yes, that was allowed. So either allow everybody who had that problem. No, otherwise there is a violation. You see, the court is also bound by Article 14.
However, no one came in this honorable court. Few of bidders came and they have withdrawn their recommendations. So they have missed out the class on that side. And with regard to district petition, they are not even participating in the PLI process. They are not bidders. So can they come before this honorable court celebrating the tender process, not being the bidders at this stage is a question signed by the others. Because they have not participated at all in the tender process.
I think, but I have sent a mail to them, I will demonstrate. Clarification, there is no reply. It's same. SPS also, I gathered information, SPS also came before this court and there was an interim order. Subsequently, they decided to withdraw it. There was no clarification there also. Same thing has happened to us. And today, my lord will kindly see what they have done. They have seen that
Edifice withdrew it.
edifice is there. SPS rolling mill has withdrawn it.
Now somebody withdrew it, no?
Mr. Bonik, man. Mr. Bonik.
Yes, Mr. Bonik has withdrawn that.
SPS rolling. There was an interim order that was passed.
This
I
one,
know
this
there's
one,
something-
this one, 2111.
21/11.
2111 is that order,
Yes, your order.
where I raised a question
Yes,
as to whether the mandate, the very sanctity attached to the minutes of the
This is-
meeting survived within the ambit of here.
but my lord, our case goes to the root of the matter. OHSAS, let them give a reply. Let them give a reply. The OHSAS is still there. My lord, it is become a redundant, obsolete. Why they have given? Only to accommodate. I am sure. Out of this 20, rightly your lordship has said 3. Out of this 20, 3. And OHSAS was my lord 2007 certificate for safety norms. And 2000 revised in the year 2018 is OHSMS. This transitional period of 3 years was granted. My lord, the same situation is that we should also give us a chance. Why not? Let the entire tenders be scrapped and new NIT should be auction notice should be issued. We should be able to participate. One day I got OHSMS certificate.
What is the order passed by in the case of Dr. BP Kudi?
My lord, this was, no, that is not it.
Kohinoor? What happened in Kohinoor?
These are earlier round,
No, is it?
earlier round, 2024.
No, it is pending, that matter is also pending, no.
Space 99 is.
That is the order, that is the order is for which one?
Withdrawn, because that's why.
This is withdrawn.
Yes, that's why effects of time it is gone. Because today, 2025, an auction notice. See 107, page 107. Para 4, 107. One zero seven at page para 4.
But why didn't you participate?
My lord, my lord, will kindly see. We don't have that OH SAS. We have, my lord, that's what confusing. We could not find anywhere. OH SAS. That has become.
No, but they had that certificate. This is what has been recorded by the learned.
My lord,
Kindly see page 96.
no, but I'll
The
tell you.
learned counsel for the petitioner by referring to
90.
the provisions of Iman, be so and so, 96, submits that the bidder is required to possess a OHSAS certificate and the same is required to be attached. Then learned area says so and so, per contrast so and so would be of no consequence, and accordingly the rejection of the bid of the petitioner would not mandate an interference by this court. This is the finding. I've heard the learned counsel here, the materials brought on record so they along with the bid did not upload the here, and accordingly the rejection of the bid of the petitioner by the email was proper. Having noticed the said position, this court also noticed that the petitioner on the last date of submission of the bid had processed a valid OS certificate which was also issued to the petitioner on so and so. And it was on account of an inadvertence that the said certificate was not uploaded. This court, considering the fact that so and so was a valid OS certificate on the last day of so and so, so and so. But he had the certificate.
No, he didn't. That's what I want to say. OHAS certificate, he didn't have. He has a certificate of OHSMS certificate.
S,
SMS.
MS, not OHSAS.
That's the whole.
Now let's see the tender.
Yes. Tender says OHSS. My lord, kindly see.
Well,
The tender comes on CF page.
Then, but the learned footnote bench held that he had the certificate of OHSAS.
I love that. Document is anything.
The A was very confounding.
No, I don't kindly see. This is what, it was not looked into it. I tell the court that this is certificate I have.
Where is the OHSAS?
Here.
Where is the tender condition?
55 kindly see, my lord, 55. If your lordship kindly see at 55, 3. Safety quality and criteria for bidders must have.
OHSAS certificate.
This is.
What is this OHSAS?
Corrected. Don't kindly see, kindly footnote, corrected on 20 feet. Kindly see the footnote, my lord, number 4. Now, 1 second. Kindly see footnote OHSAS corrected to OHSAS. It should be knowing well. It is OHSMS should be there. Knowing fully they have done it. It is not corrected. Same OHSAS, what is there to be corrected? This is optionally 20 bidders out of the 3 bidders. And edifice comes and says that he is holding the certificate. My lord, he is not holding the certificate also. He is holding some other certificate.
Yeah.
He is holding OHSMS. We have got that certificate. We applied in one day, we got it.
Which one?
OHSMS. For coming before the court, we tried, let us see.
OHSMS.
Yes, now that is, it is by there, by DCI, I will demonstrate whole my lord in this case. Well, I will take your lordship. OHSAS certificate.
Anyways, there is already an interim order there.
Yeah.
Let us take this matter on that day.
Yes.
Let us hear both the sides as well as the OHSAS certificate which the person has.
One solution from my side. Can it not be used? In particular, if we challenge what right violation they are putting before the sovereign.
But no, Mr. Counsel, you have to understand what is he contesting. He contests that you have put a clause which says there is a OHSAS certificate. You have put a clause. So obviously, I don't have a OHSAS certificate. But his contention is, there is no concept of a OHSAS certificate. It is OHSMS certificate.
Correct.
And therefore, the very clause which you have inserted
Is incorrect.
is incorrect or deficient, and for which he could not participate.
Timing of the challenge to this tender condition is after the tender process is over. It is options done. They have not participated, they have not challenged, they have set up everything, and now they come at back end of every with the case, the petition is fixed on.
Yeah, we will hear you all that day. Mr. Bonik ran away, so let me find somebody to argue.
For a moment, I want in CF page 109 for your lordship.
When we were very means just passed out. Oh, no, we were studying out there in Delhi law. So we used to go to the Supreme Court out there. So sometimes. So at that point of time, there was this direction passed. This was sometime around in 98, 99. And 95, 94, 95. That about the pollution, very strong on the green bench was there, very strong on pollution, and they closed down all these factories and all. You must have read it at the T.N. Godavaran and all that. There was another bench which was there. It was known as the Green Bench, which was headed by Justice Kuldeep Singh at that point of time. So this direction which was given means the persons concerned were means it affected all vehicles. The vehicles were closed and all these things because of the pollution. So the submission out there was, and I still remember, it was a submission by Mr. Santi Bhushan, advocate. And his tenor of submission was, one day the judges rolled down the window, because at that time you don't have this machine, rolled down the window and found some pollutant air coming with to the AC cars. Can that be a ground for violating Article 14? So we are also bound by Article 14. So therefore, we will have to look into that aspect. Let us see if that order by which has given out. Because you see, at the end of the day, you have already found out who is the highest bidder. There is no quarrel with that because there is an auction. But it is a different type of two-stage bid. On the motion day itself, that particular person was allowed and thereby allowed to participate in the auction bid. Now, if that particular person goes, the entire auction process falls because he cannot be there. Because you see, if you see that auction notice which you have placed before me on the last occasion under seal cover, it is that particular person, edifice, and there was another one where just their rates were just spiraling from one to another. So where do you stop? You get the point. Where do you stop? It may be tomorrow, if I hold that particular thing is wrong, then they may say they will pay you 30 lakhs because the other going beyond that to 80 was not required because these were the only two bidders who were submitting. The others did not lead to the auction or the enhancement of the. At the end of the time, you come out with 87 or 88 is the highest. So this is how it is.
But it can influence the price.
Yes. So because I remember that thing. So therefore, the question is, where do you stop there? The entire thing has to go. There may be, you may have to give more, the only thing is, the technical evaluation will have all those persons concerned who is otherwise qualified. And this OHSAS or whatever certificate it is, has to be exempted in respect to all other bidders. Maybe if that term is not there, then another aspect of the matter. But otherwise, what will happen is all others will have to come in. And there will have to be only thing is a fresh auction process. We are at the end of the day want the state to get more revenue. You have to understand that. If we just stop it there and we say that this particular person is not there, so it will come to around 30 lakhs, which will be very, it may not be in the interest of yours. That is why This is required to be looked at. That is why I framed that question. I would have very well said that, okay, why should I look into it? Dismiss it. Because the petitioner is the higher bidder, he is very happy with that. And but you have contested that he cannot be, because this goes against that he didn't have a certificate at that point. And the public, and this would not come under 2320 of the procurement rules, it won't come in. So therefore it is not. Anyways, let us issue notice making it returnable on 10. Only 10. I'm not saying anything. There is no interim order required. There is already an interim order. Only thing is, his case is this. So let him also argue. Let me have the satisfaction of hearing senior counsel. We don't get it nowadays. Mr. Issue notice making it repairable on 10/12/2025. His limited argument is this. There's no concept of this. So you have to only say whether there is a concept.
No, that I have written one, this is one.
It's okay.
I have, that's a,
Issue notice
Email also.
making it returnable on 10/12/2025. Mr. So accepts notice on behalf of the respondent number 1. Where is that MSTC? You appear for MSTC? No, no. Normally what happens is, if I'm not wrong, JM and MSTC is always represented as per their rules by the procuring authority. Because they are to take care of them. Otherwise, they will have a floodgates of litigations. Anyways, Arkadev Chaudhary, did you see him?
Yes, sir, I can.
Okay. Mr. Arkadev Chaudhary appears on behalf of the respondent number 2. Extra copies of the petition be furnished to the learned counsels during the course of the day. As regards the respondent number 3, petitioner directed to take steps. How do you serve him? By way of registered post, by way of speed post during the course of the day. We'll get it on 10th. The petitioner herein has approached this court challenging the requirement of OHSAS certificate as stipulated in the pre-qualification eligibility criteria for the auction number MSTC/GHY/Assam Industrial Development Corporation Limited /5/Guwahati/2025-26/25321 to be unreasonable and violative of Article 14 of the Constitution, specifically on the ground that there is no concept of a OHSAS certificate. Rather, the certificate in question, which could have been issued in terms with the said pre-qualification eligibility criteria, is an OHSMS certificate. Mr. D. Kolitan, D. Dekha, appearing on behalf of the respondent number 1, shall obtain instructions in that regard. List this matter along with WPC number. Where's the other read? 5859 of the 2005 on 10/12/2025. Only that. Otherwise, he goes.
70.
What is this premier cycle? Blacklisting.
No. The petition of participation that was issued by the Nagpuri Medical College or Lab Medical College. We had certain grievances against the qualification of the private respondent. So we submitted an appeal under section 28 of the Assam Law. it was fully acknowledged. Now, without deciding our appeal, we would actually believe that it was not the consent. Final order was passed. The authorities are proceeding to now finalize the evidence. So now my limited submission is that our appeal should be decided. Sure. Because the tender process, I mean, should be fast.
Yeah, what have you taken? What decision have you taken by the appellate authority?
But 2.0 is some of, only the work order is. That reverse the petition is that there is some proceeding pending against one of the successful bidder, the respondent prior to the hearing. Point submission will go that earlier, but the present petitioner prepared a petition whereby the private respondent was found to be L1 bidder for TMCs. For the same product, for. And a work order was issued. In the meantime, petitioner having dealing in the selection of the that particular private respondent. This honorable court interfered with the selection.
What is MOPL?
There is a private respondent. Now, my lord, when the order has been interfered with, whatever so-called be issued, my lord, for his failure to supply the medical oxygen, all has been for redundant because my lord, the entire selection must share the same very well.
Entire?
Selection, my lord, tender process. By which my lord, the private respondent was selected for what I had 2024. That was my lord interfered. He got the my lord order to supply liquid medical oxygen to all the medical process. That was interfered. Now, I didn't tell in your, when the, before in the final order, when you were supplying, that order was released. We should some supposed to. So in some interview, to interfere with that.
What is the subject matter of so-called notice?
Well, he could not, supply, as per the tender. So we have immediately issued a so request. But in the meantime, that process was interfered. Our decision to select the particular bidder was interfered.
No, the so-called notice does not automatically come to an end, but it has to be dropped.
But otherwise, yes, sir. This
It will be dropped, taking into account that he can no longer supply.
Our selection was there. So on that point, probably, there.
So they were given the direction to supply in Pen, Assam.
Yeah.
And many authorities issued so-called notices.
After that experience, it was decided that now it will be tendering these colleges, separate tender will be. All Assam tender will be after that, just PM, direct to the deal. On this point, I can have a thought instance, whether what is the status of this, because it seems to be a status.
There's a requirement to be followed under the procedure later. We have to be given like very, this has to be done, then and all.
Possible dispose of private standing. Possible direct out to this. Or not decided to dispose of the that can be done. But regarding supply of liquid medical oxygen, no, it's very interesting.
Anyways, he has last approved the authorities when?
Last approach was on 25/11. Reminder to them that I previously said. The page number 63.
So you approved some 25/11 and first you filed the request.
Because we feel that we have filed a lot. The appeal got filed on 12/6, 13/6. 13th of June itself. Since then, the mandate of law is that they have to decide on the appeal within 30 days. They were leading us to believe that we are deciding it, we are deciding it. We were supposed to receive a notice for a hearing. That has not been done.
Is it a requirement?
There is a requirement. Under the act that we have to be heard when order is passed.
So suddenly we see or while checking the status online, that now the status of the tender is showing as bid awarded. So since there were only two bidders, and we have not been given what that means that their bid has been found to be successful. So that is why we submitted the representation, even then there was no response, so we have filed it.
What happens if your appeal is allowed
We try,
and the work order has already been issued?
no, under the act, the authority has the power to cancel the work order. The authority has the power to cancel the work order also. Go for a tender or award it to us. The options are completely with them. I am not.
So therefore, there is a avenue available.
Yes.
We do one thing. Let's issue notice. This is for supply for how long?
For one day.
So the work order must have been issued recently when at the,
We made an inquiry. We were informed that on the date of, till the date of filing work order had not been. That was what we were informed.
so therefore it is 1 year.
One.
Let us assume, as he says so. Let's have it on 7th of this January. No stay. In the meantime, the appellate authority liberty be granted to dispose of the appeal if not yet been disposed of. Because if the appellate authority decides, it can already be taken care of by them. That is one. And if not, I'm here. Huh? I think that is the only way out.
But may I make one prayer?
Ah.
In the meantime, I will complete service on the access point also. Possibly make my prayer for interim relief also available on the next day. Why? Because this earlier round of litigation you ruptured. That when before it.
No, okay. We'll put it there.
Very well.
Regarding supply of medical oxygen. Staying by someone supply, be it the petitioner or the private respondent or anybody, it will directly confirm the patient.
No, Mr. Gogoi, am I passing a stay interim order? No. I am putting it for consideration of the interim order on that date. In the meantime, celebrate your winter vacation. Thereafter, we'll fight again. You should be happy with that order.
After 7 days.
No.
In the meantime, if they decide that it might.
Therefore, I am directing them. In the meantime, the appellate authority, I will direct, if not disposed of, shall dispose it of. Because this is almost a month time. Because it is the mandate of law to do it within 1 month. So if they have not, they will do it. Okay? Issue notice making it returnable on 7/1/2026. Mr. B. Gogoi, the learned Additional Advocate General, as well as the Standing Counsel of the Health Department, accepts notice on behalf of the respondent numbers 1, 2, and 3. 1, 2, 3,
6 also perhaps.
5 and 6 also.
Yes.
And performer defendant respondent numbers 5 and 6. Five and 6. Because if he doesn't represent, I can direct. Problem will be there. So let him represent for 5 and 6. Extra copies of the petition be furnished upon him by tomorrow. As regards the respondent number 4, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, the petitioner is also granted the liberty to take steps upon the respondent number 4 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner, if the petitioner takes steps, the petitioner is further directed, The petitioner shall also ensure that the dusty service is effected upon the respondent number 4 on or before 20/12/2025. The case of the petitioner herein is that in pursuance to a notice inviting tender dated where that
Page number 40, 25, 20.
notice inviting tender dated 12/5/2025 issued in the GEM portal for supply of, thereby inviting bidders for supply of liquid medical oxygen, des kilograms, cryogenic storage tanks, semicolon, aluminum or steel. The petitioner, along with the respondent number 4, submitted the bid. Where is the condition?
Petition your lordship will find at page number 48. Clause 7.
One of the conditions stipulated in the said bid document is that the bidder must submit undertaking oblique declaration that neither the bidder themselves nor any of its allied concerns, partners or associates or directors or proprietors are blacklisted or are having any pending inquiries by any government of Assam organization. It is the case of the petitioner that insofar as the respondent number 5 is concerned, 4 is concerned, there are various inquiries pending inasmuch as the Guwahati Medical College and Hospital had issued a show cause notice dated 26/7/2024. Semicolon. The Director of Medical Education have issued a show cause notice dated 13/8/2024. As well as various other medical colleges and hospitals of Assam have also issued show cause notices. All these show cause proceedings are presently pending. It is therefore the case of the petitioner that the respondent number 4 cannot be said to be technically responsive, as there were pending inquiries by the government of Assam or by the government as well as its government of Assam as well as its organizations. Per contra, Mr. B. Gogoi, the learned additional advocate general, submitted. The learned counsel appearing on behalf of the petitioner further submitted that this aspect was brought to the notice of the tender evaluation committee. However, this objection was rejected. Accordingly, the petitioner thereupon filed an appeal in terms with section 38 of the Assam Public Procurement Act 2017. The appeal was filed as far back as on 13/6/2025. However, till date, no decision has been taken in the said appeal. On the other hand, it is the case of the petitioner that there is a move on the part of the respondent authorities to grant the contract in favor of the respondent number 4. And it is under such circumstances the petitioner had therefore approached this court and have further sought for certain interim directions that pending disposal of the appeal filed by the petitioner, there should not be issuance of any work order to the respondent number 4. Per contra, Mr. B. Gogoi, the learned Standing Counsel of the Health Department, submitted that these show cause notices were a result of on account of a work order issued to the respondent number 4 for supply of liquid medical oxygen. However, there was a challenge to the said work order, and this court had set aside that work order. The learned the learned standing council further submitted that with the setting aside of the work order which was issued in favor of the respondent number 4, comma, the so-called notices which were issued had lost its efficacy. Full stop. He further submitted that there should not be any interim orders in as much as per his verbal instructions, the petitioner, the work order have been issued in favor of the respondent number 4, isn't it? Verbal instructions. That is what I said. He further submitted that any order so passed would also any order passed restraining the issue grant restraining any work order for supply of liquid medical oxygen would also impact the functioning of various government hospitals. This court heard the learned counsels appearing on behalf of the parties on the aspect of the interim prayer. It is being submitted that it is the mandate of the Procurement Act of 2007, 2017, Assam Public Procurement Act of 2017, that appellate authority is required to dispose of the appeal within a period of 1 month from the date on which the appeal was submitted. Taking into account, it is therefore the opinion of this court that if the appellate authority, that is the respondent number 5, have not yet disposed of the appeal so filed by the petitioner, the same be disposed of on or before the next date by giving an opportunity of hearing to the petitioner. This court further observes, this could also have given an anxious consideration as to whether there is a requirement of passing an interim direction today. It is the opinion of this court that the respondent authorities have to be given an opportunity to explain the case. And this is not a fit case wherein for passing it is also the opinion of this court that any interim or directions so passed may also impact today may also impact the functioning of the government hospitals. It is also the opinion of this court further opines that, that from the materials on record and the plea so raised by the petitioner, the necessity is of an early resolution of the present dispute. Accordingly, this court therefore directs the respondent authorities to bring on record their stand by filing the affidavits on or before 2012-2025. Petitioner given the liberty to file reply on or before 5th of January 2026. The private respondent shall also bring on record their stand by filing the affidavits on or before 5th of January 2026. As an interim direction, this court only directs the respondent number 5 to complete, to dispose of the appeal filed by the petitioner under Section 38 of the Assam Public Procurement Act 2017 by giving, as per the mandate of the said provision, on or before the next.
We can see. His wine shop, I can remember with. His director of shop is settled in very rural area.
Which one?
I can remember it
The earlier one is,
in urban is.
one is urban, the other is rural. Why do you make that this type of views? You should be careful. You get hold of the other person. You should be more careful. What is the urgency? Therefore, I always give, nah, don't do that. You. Here. You correction করিয়ে নিও দিওক বুঝছেন বনাবো দিও বনাইলে তো কইছি বুঝছেন হ্যাঁ নাম তো ভিতৰত লেখা আছে দিৱান সিম্পল এটা একটু আকবর আলী কি হয়েছে উপরোগ্রাম মারি একটু কারণে গুটি ফর্মখন কেনেকে আছে এইটো ফর্মখনত এইটো হৈছে কাউন্সিল secondly as a recourse that next time you won't repeat such thing, your item will be taken as the last item with a cost of 10,000 to be paid to the other side council, all three. Because of your mistake. Yes, Forest.
Petitioner Mr. Rashid. He had called for 3 times for hearing. In one occasion, he's been represented by some other person, but he is no resident of Assam, though his address is here. Now we have called him 3 times. In one occasion, his party says that we need some more time to prepare. And then third occasion we call him, he says, I am going outside, I need some time. So we also want to conclude this thing. If you are hearing and finish it off. But what people find a bunch of documents. So, sorry. Goodbye.
So it has not yet been disposed of.
No, but you will see the last communication. So first we'll see, we'll see 29/4. Yeah, it's called, he attends, proceedings have been signed, it remains unconcluded. Then second communication.
We fix a date, Mr. Gugoi, then we fix a date on which he can appear. And on that day, you hear him and finish it off.
Yes.
When?
Let him appear. What has happened here in this case?
No, we fix a date. Then later on, he can not again come.
Well,
Therefore, let us fix the date. The only dispute is that he has only enclosed one document that on 14/7 he was asked to appear, he could not appear. Thereafter, there is no other document out here. Your appeal is still pending. So therefore, you give him an opportunity.
well,
The opportunity is that is why I fixed it at 2 to give me a date when he can appear.
now, give my notes.
No, not you, you. You give a date when he will appear. And then if he doesn't appear, go ahead.
Just tell him.
Yes, that is what I fixed it at 2. He wants only a date for hearing. So once this court, otherwise it will go on like this. If I say that again to give him a hearing, he will again, this proceedings will go on like this. Because this is the third litigation.
Definitely.
Then 20 to 34, fixed at 2 p.m. for a question.
And we,
Item 19, order for impeachment.
I think assessment number 4.
why?
Order is 1025. Yes, I think I.
No, madam, I don't understand why you want only the superintendent of police, not the chief minister's vigilance cell as a party. That is the reason why I'm asking. There's no problem in making him a party. But the question is, why is it necessary to make the superintendent of police not the chief minister's vigilance cell as a party? Because that will include everybody. We do one thing, we make the superintendent, the chief minister's vigilance cell as a party. That will include everything.
Because of, benefit is not ready to, data is given by the point of minister.
So we make him a party. This is an application filed by the petitioner as applicant to implead the chief minister, to implead the superintendent of police, chief minister's vigilance cell as the respondent number 4 to the accompanying writ petition. Pusto. This court have duly taken note of the orders which have been passed in the accompanying writ petition and also heard the learned counsels appearing on behalf of the petitioner as well as the other respondents. Pusto. Upon hearing it is the opinion of the court that instead of the superintendent of police, chief minister vigilance cell being arrayed as the respondent number 4, the chief minister's vigilance cell should be arrayed as a party to the instant proceedings. Accordingly, this court therefore impledes the chief minister's vigilance cell Assam, having its office at Swatantra Senani Bhavan, Rupnagar, Guwahati 781022, as the respondent number 4 to the accompanying writ petition. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days from today. On the basis of the said memo of parties and the order passed herein, the registry shall make necessary correction in the course title and update the same in the CIS. IS stands disposed. Main follow issue notice to the newly included respondent number 4. Ms. Yudas, the learned additional senior government advocate, accepts notice on behalf of the said newly included respondent number 4. Extra copy of the writ petition be served upon her within 7 days. List this matter again on 9th of February 2026. In the meantime, the respondents, including the newly included respondent number 4, shall bring on record their stand by filing their affidavits on or before 6th of February 2026. Yes, Mr. Gogoi, you got it.
Madam, we have agreed on a 50 notice at PCCL.
Yeah, okay, fine to do. Heard Mr. H.R.A. Chaudhary, the learned senior counsel, assisted by so and so. I've also heard Mr. D. Gogoi, the learned standing counsel of the Forest Department. The present writ petition has been filed by the petitioner, seeking a direction that the petitioner should be given an opportunity of hearing by the concerned respondent authorities. It is seen from the materials on record that the learned coordinate bench of this court, by an order dated 8/4/2024 in WPC number 5638/2021, had set aside the communication dated the order dated 19/6/2021 on the ground of violation of the principles of natural justice, and with a further direction that the respondent authority to proceed afresh if so advised. It is further seen that pursuant thereto, the petitioner again approached this court in WPC number 6214/2020.
It is a different. It is different.
Okay. It is seen that the petitioner thereupon was directed to appear on 14/7/2025 by the concerned respondent authorities. However, on 14/7/2025, on account of certain personal difficulties, the petitioner could not appear. The petitioner apprehends now that in view of his non-appearance on 14/7/2025, the respondent authorities shall proceed to dispose of the matter without giving an opportunity of hearing to the petitioner. Per contra, Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, submits that the petitioner have been asked to appear before the concerned respondent authorities from time to time. However, the petitioner have not appeared. He further submits that the respondent authorities have the respondent authority wants to dispose of the said dispute as soon as possible. This court, during the course of the hearing, inquired with learned counsel appearing on behalf of the petitioner as well as the respondent as to which would be the proper date on which date both the parties can, on which date the petitioner can approach the respondent authorities for hearing. It has been submitted by the learned at the bar that on 15/12/2025 at 10:30 a.m. the petitioner shall appear before whom?
The PCCL.
Before the PCCL. Who is the respondent number? The principal secretary to the government of Assam, Environment and Forest Department.
Well,
Full stop. Taking into account the above, this court therefore disposes of the writ petition with a direction that the petitioner herein shall appear before the respondent number, before the principal secretary to the government of Assam, Environment and Forest Department on 15/12/2025 at 10:30 AM. On the same day, the same official, that is the Principal Secretary to the Government of Assam, Environment and Forest Department, shall give a hearing to the petitioner. And depending upon the hearing, the respondent authority shall take a decision as in accordance with law. With the above, the petition stands disposed of.
Item 20 to 34.
Any notification has come?
Yes.
Timeline for fire and procure and.
Okay. Now we can therefore dispose it of.
Yeah.
With this notification.
This notification has come into effect with immediate on the day.
It has come into effect,
On
no?
the next day, on the next business. I'm monitoring.
Immediate. So therefore, we now dispose of. Heard the learned counsels appearing on behalf of the petitioners in the present batch of applications, as well as the learned counsels who appear, as well as Mr. D. Nath, the learned senior government advocate, and as well as the learned counsels appearing on behalf of the respondents. The petitioners as well as the respondents in the present batch of applications. Heard the learned counsels appearing on behalf of the petitioners as well as the learned counsel for the respondents in the present batch of petitions, in the present batch of applications. This court have also heard Mr. D. Nath, the learned senior government advocate, who also represents the Transport Department in the instant proceedings.
And that is home department. Home and transport.
Home and both the home as well as the Transport Department of the Government of Assam. In the present batch of petition applications, have been initiated by the claimants as well as also by the insurance company. While the applications filed by the claimants pertain to non-condoning the period of 6 months as mandated under section 166(3) of the Motor Vehicles Act 1988, or short, the Act of 1988. The applications filed by the insurance company pertains to challenging orders passed by the learned motor accidents claims tribunals, whereby condoning the period in filing the claim petitions beyond the period stipulated in section 166(3) of the Act of 1988. taking into account the issues involved. This court, while taking up the present petition, present application, these applications, had implemented the state of Assam, the Home Department as well as the Transport Department of the Government of Assam in one of the application, that is CRP number, CRP IO number 111/2024. Mr. Dina, the learned senior government advocate, who appears on behalf of the newly implemented respondents, have from time to time placed before this court various circulars issued, interdepartmental circulars issued, both by the Home Department as well as the Transport Department. The issue involved in the present proceeding is as to whether the Learned Motor Accidents Claims Tribunals would have the power to accept a claim petition beyond the period stipulated in section 166(3) of the Act of 1988. And if not, what steps are required to be taken by the Learned Motor Accidents Claims Tribunals? Motor Accidents Claims Tribunal can do some equal. Motor accidents. Where is the government judgment? Anywhere? Anybody having?
I have it.
Hmm? Nobody has the SCC online. The paragraph change again.
Yes, this is 2023. 4 SSC 380.
Lady action.
380. 2023 for a CCTH.
The Motor Vehicles Bracket Amendment Act 2019. When did it come into effect?
Till 1/4/2022.
Which came into effect which came into effect on 1/4/2022. Had resulted in various changes to the claim proceedings to be initiated by the claimants In terms with the said amending act of 2019 and the rules framed therein under, the provision for grant of compensation under the no fault liability have been deleted and a special procedure have been carved out, introducing section 149. The said section 149 being relevant is reproduced herein under. By this section, a procedure had been stipulated by which the insurance company can carry out settlement. Upon receiving information of the accident either from the claimant or through the accident information report or otherwise, and thereby designate an officer to settle the claims relating to such accident. It is further mandated that the designated officer upon receiving the information may make an offer to the claimant for settlement before the claims tribunal, giving such details within 30 days and after following such procedure as may be prescribed by the central government. The said procedure this court would discuss at a later stage of the present order. It is further relevant to observe that in terms with subsection 3 of section 149 of the Act of 1988, if the claimant to whom the offer is made by the officer designated by the insurance company accepts the offer, the claim tribunal shall make a record of such settlement and such claims shall be deemed to be settled by consent. And such payment and such settled amount has to be paid not later than 30 days from the date of receipt of such record of settlement. It is further seen that if the claimant refuses to accept the settlement, refuses to offer, the claim tribunal then thereupon shall fix a date of hearing to adjudicate such claims on merits. This very section a perusal of the above quoted section further emphasizes that irrespective of filing any claim application under section 166 of the Act of 1988, a duty is cast upon the insurance company to appoint a designated officer, and the said insurance company and the said designated officer, upon receiving such information from the claimant or through the accident information report or otherwise, is required to make an offer which the claimant may accept or refuse. And if there is a refusal by the claimant, the tribunal, the claims tribunal, is also statutorily obligated to fix a date for hearing. Next. Section 164, as it stands today, pursuant to the Motor Vehicle Amending Act of 2019, relates to payment of compensation in case of death or grievous hurt, etc. And in which cases negligence is not required to be pleaded and proved. The said section 164, post the Amending Act of 2019, reads as under: a perusal of the above quoted clause would show that in terms of the said provision, a claimant is not required to plead or establish any wrongful act or negligence or default of the owner of the vehicle or of any other person for claim payment of compensation. A very reading of subsection 1 of section 164 shows that the said provision has an overriding effect, thereby limiting the liability to pay compensation to the tune of rupees 5 lakhs in the case of death and rupees 2.5 lakhs in the case of grievous injury to the legal heirs or to the victims, as the case may be. It further stipulates that in the circumstance the compensation is payable in any other law, then such amount is required to be reduced from the amount of compensation payable under this section. Meaning thereby the legislative intent to be clear that a person who has suffered with an accident must be compensated just and reasonably, and the victims of the family of the deceased must be paid for the bodily injury or loss of the life caused by an accident by use of motor vehicle at a public place. Next. In addition to the above, the claimants also have an option for taking recourse directly by approaching the claims tribunal by filing an application seeking compensation. The said provision, Section 166 of the Act of 1988, is the said provision. The Amending Act of 2019 have also made certain amendments. And Section 166, as it stands today, post the Amending Act of 2019, reads as under. Subsection 1 of Section 166 of the above quoted Section 166 stipulates who can be the claimants in an application filed under Section 166. The second proviso so added to subsection 1 of Section 166 by the Amending Act of 2019 makes it clear that where a person accepts compensation under Section 164 in accordance with the procedure provided under Section 149, his claim petition before the claims tribunal shall lapse. In the case of Gohar Mohammed versus Uttar Pradesh State Road Transport Corporation and others, reported in 2023 4 SCC 381, the Supreme Court observed in relation to the second proviso to Section 100, second proviso to subsection 1 of Section 166. To the effect that in case recourse under Section 164 or as per the procedure specified in Section 149 have been taken and the compensation is accepted by the claimant, but am I going to dictate on the basis of what he says, or am I going to dictate from what I feel? Get me that. Or as per the procedure specified in Section 149 has been taken and the compensation is accepted by the claimant, then recourse under Section 166 would not be available. It is further clarified by the Supreme Court in the said judgment that in case the compensation had not been accepted under 149, section 149, or the recourse of section 164 have not been taken, the claims tribunal in whose jurisdiction the accident occurred shall treat the report of then recourse under SEA would not be available. Full stop, full stop. This court further finds it relevant to take note of at this juncture. This court further finds it relevant to also observe that in terms of subsection 4 of section 166 of the Act of 1988, the claims tribunal shall treat any report of accident forwarded to it under section 159 as an application for compensation under the Act of 1988. In the judgment of the Supreme Court in the case of Gohar Mohammed, the Supreme Court further also observed that in case the compensation had not been accepted under section 149 or a recourse of 164 had not been taken, the claims tribunal in whose jurisdiction the accident occurred shall treat the report of section 100 made under section 159 as a claim petition under the Act of 1988 and may proceed to decide the same in accordance with law. At this juncture, this court further finds it relevant to take note of section 159 in view of subsection 4 in view of the discussions so made in respect to subsection 4 of section 166 of the Act of 1988. Section 159 reads as under: a perusal of the same, the above quoted section further transpires that the police officer is statutorily obligated to prepare an accident information report to facilitate the settlement of claim in such form and manner within 3 months and containing such particulars, and submit the same to the claims tribunal and such other agencies as may be prescribed. This prescription, this court shall deal with it at a later stage. Be that as it may, this very accident information report, the reference which is also found in section 149(1), can form the basis of a claim proceedings. The above analysis would further show that in pursuant to the amendments made by the Amending Act of 2019, 3 recourses are available to a claimant for getting compensation on account of an accident resulting in injury or death. The 3 recourses are: number 1, under section 164. Wherein the claimant is not required to prove negligence. But the compensation would be limited to the extent stated in the said provision. Number 2. In terms with section 149, by which the claimant may accept the offer provided by the offer made by the designated officer of the insurance company, or reject it, leading thereby obligating the claims tribunal to fix a date for hearing of the claim proceedings. The last recourse for the claimant is to file an application under section 166 of the Act of 1988. In this context, this court now finds it relevant to take note of subsection 3 of section 166 of the Act of 1988, as amended by the Amending Act of 2019. It stipulates that no claim application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. The stipulations contained in subsection 3 of section 166 of the Act of 1988 as it stands today injuncts the claims tribunal to entertain any claim application made beyond 6 months of the occurrence of the accident. Therefore, a limitation act concern. What do you say about 29(1)?
One of the languages said that who can.
No. What do you say about 29(1) of the Limitation Act?
Specifically on that, who at least shall be entertained. But the language itself, so far I understand my look, starts to know.
Have you seen 29(1) of the Limitation Act? What does it say?
There is no specific clause excluding at least from limitation. Section 3 also UPC. So
No, section 3 is different. 29(1) says, where any special or local law prescribes for any suit appeal application a period of limitation different from the period prescribed by the schedule, the provisions of section 3 shall apply as if such period were the period prescribed by the schedule. And for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local law, the provisions contained in subsection 4 to 24 inclusive shall apply only insofar as and to the extent to which they are not expressly excluded by any special or local law. But you mean to say that this has to be done in terms with the Section 34(3), the interpretation so given by the Supreme Court in respect to Section 34(3) of the Arbitration Act. Arbitration Act. Yes, Mr. Goswami, what do you say on this aspect? You see, can you come here? You see, 166(3) says that no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. But on the other hand, by dint of the Limitation Act 1963, and more particularly, Section 29(1), it stipulates that in a special law, stipulates a different period from that what has been mentioned in the Limitation Act, in the schedule to the Limitation Act. Then Section 3 shall be applicable, as well as the provisions of Section 4 to 24 shall be applicable, if not excluded by the special law. The reason being, here it is mentioned as 6 months. Can we say that Section 166(3) prohibits any further enlargement of time by applying 29(1)? More particularly, if you see, kindly see 34, how the Supreme Court said it. 34(3). An application for setting aside may not be made after 3 months of a lapse and so, and that the application has received a so and so from the date on which the request has been made. Now, this 34(3) has been interpreted by the Supreme Court. And further it says that provided that if the court is satisfied that the applicant was prevented by sufficient cause for making an application within the said period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter. Thereby, Section 5 is taken out. Here we don't have a prescription to that. Can you therefore say that Section 5 would not apply? Otherwise, they have recourse. There's no quarrel that they don't have a recourse. But in some cases, section 5 have been mandated, allowed. Now, can section 5 be brought in view of 29(1)? Because that is the mandate of law also. You see, the power to dismiss. Or one may very well say, a power to file an application is different from a power to entertain. A power to entertain is the power which is conferred upon the court. Whereas a power to file is a power given or a right given to file within a particular time. Can we make that very fine distinction? Power to file and power to entertain are two different things. Yeah, because here it takes away the jurisdiction. Can we make that submission? Can I put it in that manner? Yes, the senior government advocate.
There's never any intention to be so harsh to the agreement, and the Act says this, 166A. But the lordship may also rigid the rules. The rules make it very.
No. Therefore,
For never to out the.
no. There is no doubt that the claim applications would be taken up because it is also the mandate of law for them to do it. There's no quarrel with that.
It's very clear from the rules.
Yeah, but can this court say that in view of 166(3), it cannot be entertained? Unless this would say that the Limitation Act would not apply, because the Limitation Act only gives the power to file. The condonation of AI is not for the purpose of entertaining. Let us see section 3. What does it say? Does it say about entertaining or file? Subject to the provisions contained in every suit so and so made after years shall be dismissed after year. So this is the power to dismiss. Power to dismiss and power to entertain are two different things. Thereby you have given the power to file, and the power to dismiss. So this is the power which we exercise. But the power to entertain is different.
Power to entertain should be given law.
Power to entertain is different. That means it takes away the power of that authority. We do one thing, we'll have it again on Tuesday. Just find out that. Let me also research it because I'll continue and give it to this judgment. I know what is to be given at the end, but would it be proper on the part to say that the court does not have the jurisdiction to that?
In that context, based on the intake itself, because the power of, entertainment of the claim petition in the period of 6 months. Of course, there is no provision for extending the limitation.
No, that is why I'm saying.
But
In view of that, 29 structure.
Filing appeal by either of the parties, there is a provision of extension of time.
No, Mr. Counsel, no, you are not getting my point. By virtue of section 29(1), whether you mention or not, even if there is not a mention that the power to condone, by virtue of 29(1), it is a law that it is imbibed in this law. That the power is already given by condonation. Just for example, in this case, arbitration, the power is given to condone. It is inside because of 29. Whether you mention or not mention, that is immaterial. But therefore, my question is, there is a very slight distinction. Power to entertain may not be the same as power to file, because power to entertain is the power taken away from the court. Whereas the power to file is of the right of a first claimant to file. Here it is not mentioned that no claimant can file. If it is then 29 may strike in. But here it says that there is no power to entertain, means the power is being taken, vested away. So if the power is not there, just for example, let us take a case of a limitation act, an appeal is being filed under, second appeal you are filing with a delay of 100 days. My power to pass an order, an interim order in the second appeal, are subject to two things. First, to condone the delay. Once I delay, I condone it. Then I get the power to act on that second appeal. Now, after 3 days, after 6 months, here the statute takes away the power which is vested on the tribunal under section 166(1), 166(1). A power is vested. This power is being taken away. So therefore, this aspect needs to be looked into. And I don't have the habit of making CAB. So we'll have it, continue it again on Tuesday. Okay? This aspect we just, or tomorrow. Can you get it? Look into it tomorrow. Otherwise, I would have looked into it, but nowadays getting old, I'm not getting the time to
Tuesday will give us some time. Tuesday will give us some time.
have a look, because power to entertain and power to file are two different things. Because if I say anything, because this will have a far-reaching consequences everywhere. Because this is a route which this court have only adopted. Others everywhere there were question going on whether there should be a challenge out there or not. So this is a different aspect. So just find out. Across the table, it is very difficult to dictate. It'll put him, huh? Chalo. 166. Okay. List the matter for further deliberation on 9 at 10:30 AM. I'll dictate you, just find out. Mr. Goswami, you find out. All of you. I miss Majumdar also.
Entertainment is part. I
Ah.
could understand. A person can file, so, but can the court take a decision? That is.
Because in all other provisions, is the court will dismiss. Therefore, a power is there to dismiss.
Here,
A power to dismiss is different from power. There's no power at all.
I understood that I can file a case, no issue with that. But can the court entertain? That word entertain is very important.
So therefore, the Limitation Act under no circumstances can be applied.
That's what.
So that is what I want.
Order, interim order, has asked not to dismiss cases where because of this. I just wanted to let Lordship know. It's an interim order, not to dismiss cases under this 166(3) for the time.
That means is the provision of 166(3) has been given a stay. It amounts to a stay. Stay. But what happens? No, but not to dismiss. But what happens? But if the matter is not taken up early, then what happens?
On 25/11/25.
I think that did not,
Paragraph 5. Last.
before passing the judgment, Lordship will also do it.
Now here again, I'm telling you, this order is also wrong. What is this? Read it. Read all of you.
Is made clear that during the pendency of these petitions, the tribunal or the high courts shall not dismiss the claim petitions on the ground of such petitions as barred by limitation as prescribed under subsection 3 or section 16(3) of the.
Wait, what are these provisions?
Maybe typo.
Typo in the order. No, that is immaterial. I'm not going to use it. Interim order, there is one Supreme Court judgment that interim orders have nothing to do. Mr. Dinath, during the course of the hearing, have placed before this court an instruction, a notification dated 1/12/2025, issued by the Home Department of the Government of Assam. The said notification is kept on record and marked with the letter কিবা ABCD আছে নেকি চাব X মই এইটো মাৰ্ক কৰি দিম letter so and so. List the matter for further deliberation on so and so. We'll pass that order. The Supreme Court order. You say that you have. Good. So it has now been corrected. You're supposed to. Your mistake. Not inside, there was no mistake. But outside, even in the filing form, everywhere they have put Diwan Akbar Ali.
Okay. Item 35.
This is the notice, I think, told by the friend that some amount has been paid. I have also instructed from my client today morning that not if they will have a request to pay this bill. But if they are satisfied with the amount of what they have.
No, curious. We to dispose of that. Okay. Okay. You don't want to press this. Mr. DJ Das, the learned counsel appearing on behalf of the petitioner. And Mr. D. Gugoi appears on behalf of the forest. Department. The learned counsel for the petitioner submits that he has instructions to withdraw the instant petition. Taking into account the above, the writ petition stands closed. On withdrawal, interim orders, if any, stands vacated.
36.
Yes, what is your instruction?
Because the last order, the lordship perhaps quite update. Lordship, as per regulatory lordship, with regard to the two schemes, it would be considered in the financial year of 2025 and 2026.
Huh?
Regarding the four schemes, the lordship, the payments already been done.
Isn't it recorded in my last order?
Lordship, is lordship,
So kindly come to the point. What is the point I've asked for?
lordship, do not have that.
What about the first work orders at serial number 269 and 334, 364 of the chronological order?
That-
They have been put in the chronological order. In which list? You have a consolidated list 1, consolidated list 2, which one?
That effect lordship, need to in a clear instruction.
After 3 months.
Lordship. We had a lordship, but this is the first.
Sorry, state of affairs.
Lordship. For the first time we have created as new councils the lordship. If the instruction will make sense. Lordship can dispose it of that day, lordship can dispose.
The instructions which were sought for by the order dated 17/9/2025 could not be placed by the BTC Council on account of the fact that they have been newly engaged post the election. List this matter on 7th of January 2026 for an update. On which date? On 7/1/2000, on which date? The council appearing on behalf of the BTC shall ensure that the instructions as sought for by the order dated 17/9/2025 is available.
Item 37 to 40
What are these? Yes, where's Mr. S. Doctor? He comes up with all these things that he's going to obtain instructions in view of the reply. What happened?
Yes, discussing with the department, so they will get. Contract.
How much? Ms. Enbora, appearing on behalf of the PNRD. 2 weeks time for filing a rejoinder to the affidavit in reply filed by the petitioner in all the matters in the batch of petitions. To list the matter on 9th of January 2026. In the meantime, the rejoinder affidavit be filed by 7th of January 2026.
Next.
9, 1 day before Bihu vacation. Why? No, not necessary. Yes.
Paid the principal sum of 6,46,809 rupees, the transfer. The amount was transferred yesterday. And as far as the interest is concerned, we are only seeking a week's time, my lord, because of their cash flow issues with the company. Once the revenue generating activities commence, will pay off the interest.
How much would be the interest? 9% interest on 6,42,000 for the last 7 years. How much? You have calculated it. No, as on from with effect from 2/5/2018. What is the interest component? What are you looking into? What are you looking into? It is not there. I've asked you, therefore, my order was very clear. 6,42,809.26, along with interest at the rate of 9% on the said amount from 2/5 to date till realization. Meaning thereby, this is the thing which you have to work out. Principal, there's no question of payment of principal. You have only paid 6,42,809. The apportionment will be first towards the interest. So this will be taken from the interest and the remaining against that this will happen. Do you know the difficulties you have put yourself into? You have paid the principal, the interest first. First you pay interest, then cost, then this is the law. So you have paid the interest first. Then
Around 6 lakh.
huh?
Overall, 52,600.
Pay that. Otherwise, interest will be too many. If you don't pay, this will have a problem, no? Not 3 weeks. We have to finish it by 17th of December, you make the payment remaining. If you don't, I can stop the interest. You don't go into that any further. And about that amount, you pay that by 17th. Otherwise, what will happen is, this amount will be taken from there. So just for example, he has now come up and says that it is 4 lakhs. 62,000. And what is this with the principal? Edit for, do you want this code to edit?
11 lakhs something.
Okay. So now what will happen? 11 lakhs, out of that you have paid 6 lakhs. 6 lakhs will go there. But the principal remains, so the interest of 9% will keep on accruing. You don't stop by making payment of the interest this amount only. We'll have it on 17, complete the whatever may be. List, it has been submitted that certain amounts have been paid to the petitioner, to the respondents. Petitioner, no? To the petitioner by the respondent number 5. Full stop. Some time is requested for further payment. List the matter on 17th of December 2020, 18th of December 2025 for an update. One more day I'm giving you.
43.
Better it's pertaining to down payment of the part payment of the out of the 3 crore 73 lakh 13,213, 2 crore 93 lakh 38,453 already paid.
Mr. Hendik, yesterday's matter, I did not pass that order, sign that order in that manner to be listed before any other bench. Because that would be doing disservice to the client.
That is true.
Although the counsel for the petitioner was not ready, he should have come up in that manner. So it is not for this court to always help that. How much to help it? But then also if I don't do it, that person would never get anything. So therefore I'm having it on 11, putting it as Mr. A. Gayan was not present yesterday. So we'll take it up again.
11 is gone.
11, 12.
11.
Because she was not present that day.
Let them not go on, obviously, closing them.
How much should I explain? But then
They
also,
should understand well what is the interest of government.
Hmm.
I also agree that well, there's some process that the person who are passing the
no, there's no quarrel that he's entitled to the relief. But the
He's
relief,
entitled.
but he has to help, he has to find out the way. He cannot come up out there and say, look here, my land has been taken. It will never happen, neither come to an end. Yes, what is it?
For non payment of traffic. Out of the 3 crore 73 lakh, they have already paid 2 crore 93 lakh. And balance is 79 lakh 74,730 has not been paid. The respondent number 4 has filed an affidavit by saying that they have the non-allocation of the budget by the even when DM department, they could not pay the check. That is the extent of respondent number 4.
We passed the order, same order that day we passed.
Day before yesterday.
Day before yesterday, that order which I passed, that only order. There also that district commissioner had admitted 44 lakhs, 52 lakhs. And then also I passed an order to make a verification because his submission is, as would be seen from the revenues affidavit, they say that we are looking into from the indents and bills. So there will be a requirement of carrying out the verification. So therefore they will verify and find and pay.
But
That is the
in
order.
that case, well, the entire amount has not been paid. But here in.
No, here we are only concerned with 79 lakhs.
Yes, 79 lakh.
So this is admitted at paragraph number 5 by the respondent number
Yes,
4.
yes.
But the respondent number 3's affidavit is that they have received these indents and all, they are verifying it. So therefore they will verify and pay you within 6 months.
In fact, well, they have verified and we paid the earlier amount. Whatever we already about 3 months were given.
Chalo, we do one thing, let it come up after 4 months. Huh? We will hear the matter improperly. Okay. List the matter after.
Same way.
And department also, my love, because they don't release the amount by.
Huh?
Because direction.
No, the direction is to everybody to make the payment. So it will be the same directions out there. So here, respondent number 4 has duly admitted at paragraph number 5 to Lekki River. However, Mr. J. Hendik, appearing on behalf of the Revenue Department, submits that the respondent number 3 has filed an affidavit in opposition, wherein it has been mentioned that the indents and bills of the petitioners are being looked into, and they should require further verification on from their end. Taking into account hetu similar direction, hetu did.
Forty-four. Earlier of this one, I think people were rushing. The amount due under the they also admitted one that is not paid. The portion will be equal. This 27 is the order in the last portion. There are 618 days.
The problem is there. Your irrigation. Tamser Ali does not apply. Earlier order says of the Tamser Ali. Wouldn't this court now be sitting over that order? Give me a solution.
Is this one of the
Earlier, your client got an order to make payment after verification as per Tamser Ali. Tamser Ali says up that there is a particular chronological list. They don't have a chronological list. Then what to do with this order?
they have to make it. First, my lord, you are not.
They say that we don't have a chronological. How do you see, if I pass an order, wouldn't it go contrary to this order?
Your lordship would be pleased to see 25. They are not, they do not make this chronological order, that is their partner. But
You got that order. No, Mr. Counsel, the problem is you got that order. Mr. Imtiaz, learned counsel for the petitioner, has submitted that the respondent may be directed to take immediate payment action for disbursement of the amount immediately in terms of the principles laid down in Tamser Ali. That's your submission. Court passes an order to pay as per Tamser Ali. They don't have Tamser Ali.
that plea is not taken by them. Their plea is this, the government is not sanctioning their amount. Your lordship would.
Have they filed an affidavit?
Case 25, you will not file.
Then
Case 25, your lordship.
Lordship, I think the letter. We structure.
you file an affidavit. No, Mr. Sheikh, you understand, appreciate. I can, any order otherwise, if I don't get something out there, it becomes very difficult for this court. Otherwise, this court would be sitting over the order passed by a learned coordinate bench. You hope, I hope that you are going outside would not laugh, look at this particular judge.
The chronological order is not with the irrigation department.
That is what problem arises there. Okay, then I think I need to make one thing very clear. Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner, and Mr. N. Upadhyay, the learned standing counsel appearing on behalf of the irrigation department. The learned counsel appearing on behalf of the petitioner submitted that this is the second round of litigation. Inasmuch as on an earlier occasion, the learned coordinate bench by an order dated 31/3/2023 in WBC number 2626/2022 directed to carry out the verification and make payment to the petitioner. Of an amount of the entitlement by following the directions contained in the judgment of the learned full bench in the case of Kamser Ali and others versus State of Assam and others reported in 2008, 4 GLT 1. This court inquired with Mr. N. Upadhyay, the learned standing counsel of the irrigation department, as to whether the irrigation department maintains a chronological list as is done by the PWD department or by the BTC, comma. The learned counsel submits that he would obtain instructions and file an affidavit in that regard. To list this matter again on 9th of January 2026. In the meantime, the affidavit be filed on or before 7th. By this, we can tweak it.
45.
What is this?
Regarding tender,
Huh?
Concept here under Sendai, I think also just took this time, you also may take it up next week.
under September, the last quarter also they said that they received the application.
Also,
Make submission as per what you have submitted earlier.
that's also it was sent for making also some.
What vetting? How can I give? When you say that the learned standing council agriculture department to the effect that the affidavit has been received by his office today.
Also, instruction also. I paid that instruction.
When are you filing it?
Also, by Friday, you also may take it up next week.
Mr. B. Chaudhary, the learned standing council of the agriculture department submits that the department shall file the affidavit without fail on or before 5th of December 2025. The list the matter again on 10th of December 2025. On 12th of December 2025, liberty given to the petitioner to file any reply if any.
46.
No, tender my lord, to get a construction yard, academically, this case was found to be my lord, lowest. And the committee of the second bill. Now, if you implement, it doesn't hide. For every, it complaint filed by 1% on that of 15%.
Huh?
The complaint filed by 1%, meaning that the road is in his land.
Why you are not giving him the tender, being the lowest bidder?
So I am appearing for 456.
You are the main person.
56.
Why you are not giving him the tender in spite of finding him the lowest bidder?
What happened was it, for issuing the work order, one resident of that locality filed a complaint. That
Ah.
complaint is, NIC has placed 32 of our ability. He stated that, the proposed road to be constructed, proposed road is going across some Patale. So he raised some objection. Accordingly, a tender, meeting was held, tender regulation committee of the board. And in that meeting, board took the,
So are you abandoning the project? Are you abandoning the project?
not yet, but we requested the particular complainant to give consent. So that we can.
Mr. Counsel, I have read paragraph 6. You have mentioned that in paragraph 6 of your affidavit. Therefore, I am saying, in that paragraph 6, you say that you have requested to the Pattada to give the consent or as well as the no objection, but he has not given it. Therefore, my question is, the next step, are you abandoning the project?
Still not.
So he still may get it.
Complaint can be value, 1% health complaint on level 15%. Secondly, value that the road was is distance is 70 years. This 70 years road is there. Is 36 and similar. The letter is by the chairperson of the letter of the committee. Is 36, then middle paragraph.
They duly admit that we understand that a portion of the land required for this road and drain development belongs to you and 14 other individuals.
On what basis they agree, that is not also there, but 70 years, 70 years road is there. Still 70 years, that is also there. On what basis they have not taken any report from Central Officer also, no demarcation.
No, but if it is not their road, they must have got somewhere something. Because otherwise the money will also go away.
Road is, same 70 years. Now repairing of, only repairing.
The road is in existence. The road is in existence in long back.
So why is he raising a complaint? This fellow, Dilip Kumar Saha, you make him as party.
No. Not right now, they have money.
You make him a party. This is a positive direction. Then we will consider. And ask him down what document he has. Mr. HR, Ahmed Dalani Council appearing on behalf of the petitioner submits that the petitioner would like to file an application seeking impleement of the complainant whose name appears in Annexure 7 to the affidavit in opposition filed by the respondents numbers 4, 5, and 6. Whose list this matter upon such application will be filed.
Mr. Van.
What is this? And after completion of the state work and handing over to the satisfaction and the payment of the to which it belongs.
Because proposal has been sent to my lord,
Huh?
release the fund, my lord. Proposal has already been submitted, to release the fund.
Where is the proposal?
Yes, sir, page 69. Oh, I agree.
Where is the petitioner's name? Huh? Is it there in the page 69?
Oh, whole project, my lord. There are 5 content, my lord.
So you admit to that amount?
Yes.
Chalo. If you admit to say too. Where is your admission?
There are 5.
Where?
There are 5.
No, where is the admission that he is entitled to this? 10 lakhs.
Work has been completed, my lord, as per council, has been issued, my lord. Yes, sir.
Whether he is entitled to or whether they also say payment will be subject to these 10 may be equivalently clear and so and so. Where is it mentioned? You have mentioned that he is entitled to this 10 lakhs. It is a specific case that he needs 10 lakhs. Isn't it, madam? It is saying that the respondent number 8 has filed an affidavit in opposition. In the said affidavit in opposition, the respondent number 8 have mentioned everything except the query sought for. The query raised by by this court in the order dated 23/7/2025 as to whether the petitioner is entitled to the amount of rupees 10 lakhs as claimed in the writ petition. Taking into account the above, this matter again on 17th of December 2025. In the meantime, the respondent number 8 is directed to file an additional affidavit clarifying the said aspect.
48.
This already have filed an affidavit. We have to take file that plan. So they will better.
Who has filed affidavit in opposition?
The APC authority.
AMC.
Yeah, they file that plan. He is not on record.
You filed your reply also.
So they come up to next week.
On account of late handling of the possession which the petitioner states to be 260 of the VIS. So for waiver of the case money, say respect which it is submitted that an affidavit in a reply have been filed by the petitioner. However, the same is not on record. List this matter on, I'm not there on 15th of December.
49. The month of January.
Can I?
Nobody is working on. You're only claiming some deduction in the the annual revenue.
Okay, chalo. So again, I put it in my hands again. On 28th of January.
I have some more tactical. Construction from SP with Kalyana. But sometime the DC also hire the vehicle. Receive the instruction from DC.
Okay, the instructions as sought for by the order dated 28/2025 have not been placed before the before the learned government advocate. Full stop. And as such, Ms. Yudas, the learned additional senior government advocate, seeks for another 2 weeks' time to list this matter on 31/2026. In the meantime, the respondents are directed to bring on record their stand by filing the affidavits on or before 22nd of January 2026. Failure to do so, this court shall deem, this court shall apply the doctrine of non-traverse.
50.
Payment.
Requisition for this course. They have
No.
accepted an ITI reply. Have an ITI reply, they have accepted that.
Which department?
There is the police.
Home and political. Police. Any instruction, madam?
Says for the ticket amount is 3,6,990.
With me.
I'm claiming this. This, that.
Instruction kept in record as X. On the receipt payment status on so bill submitted. Amount has been paid.
Yes, sir.
This is the one which he is asking for. I have the honor to inform you that as per the report received from the Suez, it is found that the outstanding claimed amount has already been credited to the bank account of the petitioner on 22/10/2025. A copy of the report received from the additional so-and-so is so-and-so. Financial sanction 5/5/2025, bill number so-and-so credited on so-and-so. Stop. Got the money. Dispose of no has submitted. And again, you ask your client, huh? Miss Yuda, the learned senior government, additional senior government advocate has placed before this court an instruction dated 1/11/2025 issued by the district deputy commissioner of police crimes, wherein it has been duly mentioned that the petitioner have the amount of rupees 3,58,099 which is claimed by the petitioner have already been credited to the bank account of the petitioner on 22/10/2025. The said instruction is kept on record and marked with the letter X. Good stuff. Mr. So-and-so, appearing on behalf of the petitioner, submits that he will obtain instructions in that regard. List this matter on 11th of December 2025.
If you are. Very last order.
Last order was PNRD did not appear. Undertakes on the basis of instruction from the CEO that the affidavit in here. What is my order? I must have passed some order. That quoted an amount of year which was within the ambit of 10% of the government value of rupees. However, the respondent has quoted so and so which far exceeds 10% stipulation contained in one as well as clause 1 of the agreement. What is the date of the year? Okay. Yes, what is your case? How are you giving it to so much at a year?
Also, one detective tender.
Yes, it is in violation to Rule 47.
Sending committee not follow the rule 47.
Did not follow. And not only the executive instruction, everything is there. Hello. NIT clause 12 and Rule 47. Rule 47 came into being on 21/4/2025, na? When was the amendment to Rule 47? The new book? Hmm. We have an old book, we can exchange it with you. Yes, 2nd of April 2025. So your decision which was taken, notice inviting tender was on 10/5/2025. So you didn't follow, neither Rule 47 was followed nor this. Where is the other side? Not appearing. Okay. We allow your petition only to the effect that we set aside him. And thereupon you can take a decision. How to run it. You want to give it to him, you want to give it to anybody, but you have to follow the law. You are the very good, you are the valid with the devil. No, but Mr. Counsel, you have to appreciate. This court doesn't have the power to give it to you or direct them to give it to you. There are many things. They are to do it. So I leave it to them. Make it very clear that they should give it to you. He is the, shall take into consideration he is the otherwise the valid bidder. Thereupon what they do, that is their lookout. We'll dispose it of. Huh? You get the order tomorrow. Chalo. Kita matter asin. Good matter. Just poison.
52.
We are keeping the book for the time being.
Yes.
What is this?
Is there a policy for not filing the,
Oh, yes. Why you are not filed?
putting the finalization of the concerned official
Ah,
in this post? So a couple of days time is.
okay. This matter. So it is seen that the affidavit on behalf of the sole respondent have not been filed. Post of list this matter again on 28/1/2026. In the meantime, the affidavit be filed on behalf of the respondent on or before 21st of January 2026. Liberty given to the petitioner to file reply.
23.
What?
Regarding on the non-registration of the petitioner as pharmacist, the council.
Ah. So you said that you had the instructions.
Some documents, information are required by the company. Non-cooperation is the problem.
After looking into the file of so-and-so verification number of acts found that he passed HS from so-and-so. Number failed in theory of the subject. Later again, even after 11 years, he passed HS exam with chemistry under recruitment scheme mentioned in market fund. Then today took admission in pharmacy course at so-and-so Meghalaya. He had 2 marksheets of passing HS exam, one 2008 from Iman, 2019 from so-and-so. So he should tell us by which certificate or marksheet he took admission and gave it. Then, do you have some method by which he can go and meet you?
We can approve the registrar of the.
Let him approach the register office and the register office will intimate him the reasons for non-consideration. I think that is the best way to keeping this. I'll quote that paragraph 4. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi appears on behalf of the health department, appears on behalf of the respondent numbers, all the respondents. The petitioner herein has approached this court, being aggrieved by the non-consideration of his pharmacy license, which he submitted on 11/6/2024 by the application number APC/F/2024/9426. In pursuance to the notice issued by this court on 12/11/2025, Mr. B. Gogoi, the learned counsel appearing on behalf of the respondents, have placed before this court a set of instructions issued by the Register Assam Pharmacy Council, which is kept on record and marked with the letter X. At paragraph 4 of the parawise comments, so provided, reasons have been given as to why the petitioner's application have not yet been considered. So taking into account paragraph 4, taking into account the relevance, the said paragraph number 4 of the instruction of the parawise comments is reproduced here in under. Next, it is the opinion of this court that the respondent authorities, that the respondent authorities, more particularly the raised the Assam Pharmacy Council, the opinion of this court that the petitioner should be given an opportunity to explain to the register Assam Pharmacy Council, who is the respondent number 4, to the present proceedings. In respect to the queries which have been mentioned in paragraph number 4 quoted herein above, of the parawise comments as quoted herein above. Full stop. This court therefore inquired with Mr. B. Gogoi, the learned counsel, as to when can the petitioner approach the respondent number 4. Yes, when?
Next weekend. Within 7 days,
Any date? He submitted that the petitioner can very well approach the respondent number 4 on 13th November, no, not 13th, on 11th of November, December 2025. So taking into account the above, this court therefore disposes of the instant writ petition, thereby granting liberty to the petitioner to approach the respondent number 4 on 11th of November 2025 at 10:30 a.m. Also, upon the petitioner approaching the respondent number 4, the said respondent shall explain the deficiencies in the application of the petitioner and thereupon consider the application as per law. You, in the meantime, take a call from these people and ask them if it will be 10, 11, 12, because that person may not be there also. And tell her before that order is typed.
54.
UN construction. Oh, this one.
The representation has got been disposed of. Also by directing them to dispose of petition from base to public. So consider the same and dispose of. Taking consideration the compensation rate there.
Why you're not disposing it of? It was given such a long time back.
Sometime to be fair. To be fair.
Well,
So hearing the petitioner also because this will need some negotiation also.
no, we keep the matter pending because you see, you have a bigger issue. The bigger issue is first we have to find out as to whether there is a dispute or not.
Yes.
If there is a dispute, we can go on the 24, 25. If there is no dispute, then the other thing finishes. So therefore, let us fix it on in the first week of January. In the meantime, let them dispose of by giving you a hearing. Huh?
You have to complete the.
By giving you a hearing
Yes.
in the meantime
Yes.
and give an update before this.
Commission.
Full stop. It is seen. The pursuant to the order passed by this court on 26/11/2025. Mr. B. Gogoi, the learned standing counsel of the respondents submits that the representations were submitted by the petitioner on 11/9/2025 is yet to be disposed of. Mr. B. D. Das, the learned senior counsel appearing on behalf of the petitioner, submits that while disposing of the said representation, the petitioner may be afforded an opportunity so that the petitioner is able to explain its stand. Considering the above, this court fixes this matter on 21st of January 2026. In the meantime, the respondents, who is that? to whom you have submitted,
Respondent,
the respondent number 3 shall inform the petitioner of a date of hearing and thereupon make an attempt to dispose of the representation and submit a report on the next date.
Decided by the chief engineer, respondent number three will not be in a position.
Representation is report as respondent.
Who is respondent number 3?
He is only executing, respondent number two and three is the chief engineer.
Representation is to whom?
Respondent number 3.
No, 3 can't do it. It has to be by the 2.
Respondent 2 and 3.
Respondent number 2 and 3. 2 and 3.
The respondent.
The decision be taken by the respondent number 3 in respect to the representation.
After consulting with her.
Huh?
And after consulting with her.
I think the chief engineer is the higher authority.
He is the respondent.
So therefore, I'm directing the respondent number 2 to dispose of the representation. No, no. It is the opinion of this court that the representation so submitted is required to be disposed of by the, is to be decided by the respondent number 2. And accordingly, this court therefore directs the respondent number 2 shall in the meantime, in the meantime, inform the petitioner about the date of hearing, and upon hearing the petitioner, make an attempt to dispose of the representation and provide an update on the next stage.
If I,
The last.
So more than
Only
that,
small issue, my lord. Without purpose, my lord, in violation of section 52, there, my lord, continue with the order.
How much? He wants to open
Yes.
on 1st of January 2026. Isn't it?
Yes.
was
He wants to.
that by the
So therefore, whatever instruction has to be there before 20. So that I can pass an order in his favor before 20. 17.
Subject to effect. Subject to effect, my lord.
The instructions sought for by this court by an order dated 26/11/2025, however, have not been placed, was of taking into account the allegations that the continuation, that the suspension order have continued beyond the permissible limit as mentioned in clause 15 of the Assam Public Distribution Order 1982. This court grants a final opportunity to the respondents to bring on record a stand on or before 17th of December 2025. List the matter on 18th of December 2025, on which date an attempt shall be made to dispose of the requisition.
item 71.
AFDC, what is that? Linkage Chaudhary, Moriga, subsequent to Yes, what is it?
Relates to remission, my lord, and readjustment of.
Respondent number 5 was directed to file an affidavit. File. Who is 4? What does he say?
That's literally good.
Yes, why are you not considering the representation? How long?
But it is not in report. They filed an application.
Okay. It has been submitted by the learned counsel appearing on behalf of the AFTC that the affidavit has been filed. However, the same is not on record. Affidavit of the vacation. This matter again on 28/1/2026. But in the meantime, the petitioner is given the liberty to file reply.
72.
It is complete and that you must clear and file already filed their affidavit. And the
What do they say?
reference number three is filed in the police. And the admitted that the vehicle was acquisition and the proposed vehicle forwarded to the city customer Valpara.
How much?
One of the pending deal is 9,5,369.
Yes, to verify, so
What is this agreement for sale of vehicle?
Agreement between petitioner and respondent number five. Respondent number five is the registered owner.
Who is the petitioner here?
Hello.
Who is the petitioner here?
Petitioner, the purchase the vehicle from the, but due to some illness of the wife of the respondent number five, vehicle could not be transferred. In the meantime, vehicle was acquisition.
Now, have you got it?
No, the vehicle, yes, vehicle was returned to me and now vehicle has been, given to them, because it is always damaged.
To whom?
Them, it is. To them.
Them. Something is there. You have given to whom?
Well, vehicle was returned to me and thereafter, yes, yes, because it's not motorable, so vehicle has been damaged, sold to them.
But you are not the owner.
That's correct.
Scrap.
That's correct.
Okay. Now tell me one thing. You are not the owner.
I am not the registered owner, but registered owner is the restaurant number five, Malana.
Find my affidavit number. And I have stated that I have no fixed outstanding dues or paid to the DPW.
Verification. Verify and pay. এখানে one affidavit filed by respondent number five, who is the registered owner who has no clear objection if the amount is paid to the petitioner. Respondent number three have stated that the vehicle was taken on hire. However, there is no mention as to what is the actual due. Considering the above, so এখানে that verify করবো police, normal police verify and then make payment. Six. An affidavit consignment. Oh, Dhansuri truck owners. What is it? This is a case where you need to file affidavit, not instructions won't do. I think you bring it. The notification dated so and so have been kept in event and entry posts are living so and so. You file an affidavit. I'm bringing on record these notifications. Very confusing. No, very. It is seen that the affidavit on behalf of the KAC have not been filed in spite of specific direction given by the order dated 12/11/2025. List this matter on 21st of January 2026. In the meantime, the affidavit be filed on behalf of the KAC on 19th of January 2000, on or before 19th of January 2024, without fail.
74.
Oh, why haven't you issued the?
The area. Field side cut and landing bazar for center, Dolipur Anjali Content, Hotel or Lubri Municipal Board. So for that purpose, we have already said that the certificate for site. So the project is not.
You put this on affidavit? Miss N. Borai, learned standing counsel of the PNRD department submits that in view of the Walpara, the Dhubri Municipal Corporation coming into existence, didn't it? Pursuant to the Assam Municipal Corporation Act 2022. Issues have arisen as to whether the Dhubrichor Hat and Doinik Bazar fall within the ambit of the Gaon Panchayat or the Dhubri Municipal Board, Municipal Corporation. First, she therefore submits that the learned counsel further submits that in that regard, this court, the required information have also been sought for from the circle officer. So the taking into in that regard, therefore, there is a delay. Therefore, no steps have been taken for settling of the Dhubrichor Hat and Doinik Bazar, isn't it? For the year 2025-26, it is the opinion of this court that the said aspect be brought on record by filing an affidavit so that the petitioner herein can have an opportunity to revert. List this matter again on 28th of January 2026. You can file it beforehand. We can finish it off. This is the point. So you see, if that is so, he gets the reason. Taking into account the above, list this matter on. It is the opinion of this court that these instructions be brought on record by filing an affidavit. Reply to Bhatti. List this matter on 19th of December 2025. Affidavit be filed by 18th. Only that point, you just really we close it because that is the reason. He wants a reason, this is the reason.
Order Item 56. Final God won't play in this case. Still will face the instruction of the next day.
No instruction, this is contempt. There is no contempt.
Regarding the consultant list, because this is complement of this. So we'll produce the list.
Mr. Counsel, this is a contempt matter. Contempt matter, first requirement is you have to purge your contempt. Where is it? You want to produce instructions? What is this? Mr. So-and-so, the learned counsel submits that he has been recently engaged today. He has been engaged today to appear on behalf of the respondent number 3 and seeks some time to file the affidavit in opposition. To submit this matter again on 2nd of February 2026. In the meantime, the affidavit on behalf of the respondent number 3 be filed.
57.
Yes, what is this?
Pertains to make a non-payment of potential bills. One kind letter, two letters, like item 57 and have received the subsequent verification. API on behalf of respondent 1, the officer is a
So you say that within 4 weeks you are going to do it.
complete the process, they say. They say it will complete the process and finally money will be sanctioned. Then it will be final to the finance department.
Let them make the payment if he is entitled to. If he is not entitled to, forget it.
Because that they will from 4 weeks time.
Last time also sought for 4 weeks, exactly 4 weeks. Same order passed. Yes, is underway and a further period of 4 weeks. So this is the third time, second time 4 weeks.
Third time.
Oh, third time, 4, 4, 4, 12. That happened like this. We should see the face of this person concerned, not through video conferencing mode, but in person. Let us see who keeps on. This is also a contempt, isn't it? Every time asking for 4 weeks. Giving a false undertaking before this court.
Director,
Huh?
I will bring this instruction by filing an affidavit.
What is the direction passed?
Direction by the outstanding bill in terms of my subsidiary.
Huh? Where is the order of Tamsir Ali? Lego. This is an application filed alleging willful and deliberate violation to the order dated 5/8/2024, passed in WPC number 2814/2024. This could have duly taken note of that whenever the matter is being taken up since July 2025, the respondents have been seeking for either a month's time or 4 weeks in every intervals. Today also, the same plea have been made by the instruction issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department. This stand so taken by the respondents do not inspire the confidence of this court that the orders passed by this court have been, that there is a bona fide attempt on the part of the respondents to comply with the orders passed by this court. Considering the above, list this matter on 18th of December 2025, on which date the respondent shall give an update as to whether the financial sanction has been granted in respect to the payments to be made upon carrying out the necessary verifications. See, this order now will help. Same. The number to बोलना नहीं.
Nine.
What is this?
Lordship,
Yes, Mr. Barpuzari, I will ask you after some time something. Wait, don't go.
Final level is applied. And we have prepared it so. But due to certain unavoidable circumstances, the petitioner could not come to Guwahati as he resides in Nimrod. So therefore, we completely puts on the book to kindly fix the matter after vacation.
6 months?
Lordship, we have prepared it so. Just for swearing the affidavit, we are waiting.
Counsel appearing on behalf of the petitioner seeks a further accommodation to file their reply, taking into account that the petitioner, on account of his personal difficulties, could not come to sign the affidavit. List this matter on 11th of February 2026. In the meantime, the reply be filed.
Keep your best precaution.
60.
Oh, this one. Huge amount. Anything compliance?
So far as the amount is concerned, the supplementary demand has been approved by the assembly. This time. So we are waiting for the assent of the governor. Thereafter, the concerned department here at home, they will submit proposal for sanction to the finance department. And FOC, then it will be released.
How much?
I think, the basically, in the first week of January.
What?
There's some monitoring in there, that already 4 months period.
Understood. So what should I do now?
I have to pay them 6 or 8 people.
Why? How can we say that? It's too early, no? Let's have it in the 3rd week of January to get an update. Because here we have not yet issued notice. He has made that submission, I'll record it. Once we record it, then let's see. That is the reason why I have not issued notice. Then I find out. If they find out, then in that case, whenever I issue a notice in these matters, I'm very strict. Once I issue notice, I take it out. This court had requested by an order dated 19/11/2025, Mr. B. Gogoi, the learned additional Advocate General, as to whether the order passed by this court dated 25/6/2025 in WPC number 4516/2023 had been complied with or not. Mr. B. Gogoi, who is the additional Advocate General for the state of Assam, is also the standing counsel of the Finance Department as well as the Public Works Department. He submitted that after consultation with the various authorities, they have informed the petitioner, they have informed him that a fund, a supplementary demand have been made for the purpose of supplementary demand has been made for the purpose of clearing the outstanding of the petitioner. The said supplementary demand is required to be given the approval by the governor.
No, the demand has now been passed by the honorable assembly.
Full stop. The said supplementary demand have already been passed by the assembly, by the legislative assembly,
Now we are waiting for the assembly.
and is awaiting the assent of the governor. He further submit that pursuant if the upon granting of the assent, the necessary FOCs would be issued, and thereupon the amount would be credited to the petitioner. Full stop. Taking into account the above, it is the opinion of this court that a further updated status may be awaited till prior to issuance of any notice in the instant proceedings. List this matter on 24th of January 2025 for an update.
61, 24, 126.
Eh?
24, 126.
24-1.
24,
Oh, no. You know, again, now you see the problem which is happening is sometimes I watch this is the other one. No, we have it, no, 24 is closed. 24 is closed, so we'll have it on 28. 28 one. Because there is only 4 days of holiday. এগুলো তো বহুত সাবতে মু সব বন্ধ হয়ে আছে। But silent. Yeah, the problem is two calendars. Sometimes it catches this one. I should stop giving dates, then it is better. Then it is useful. What is the same matter, Mr. Alam?
No, not same. There Lordship may see the outer weather. Yes, cover.
Whether this court has directed, this is an application alleging here whereby this court has directed to carry out re-verification of the outstanding dues of and thereupon pay the admitted amount. It was that on so and so there was duly intimated about the order. The learned counsel has submitted that this can be also be seen from the communication dated so and so. So whatever submitted that no payment has been made thereupon even after the expiry of your present application. Yes, why no payment?
By instructions, I waited.
This is too long, huh?
The then on 18. So it is regarding the verification part. So there are 2 full orders.
Verification is already done. Verification has already been intimated to him, isn't it? But what is the department?
PWD and
Huh?
PWD executing department.
Health department is there.
Health and PWD.
Here the chief engineer has already said that you are requested to take necessary action on the matter from here. Huh?
For the vacation, at least the update.
The update as sought for by the order dated 19/11/2025 by this court could not be placed on account of want of instructions. List the matter from in the motion hearing. The motion issue, why not? No notice. Taking into account the above, list this matter again on 19th of December 2025 for an update at the stage of motion. And you don't need to wait for
63.
service complete.
Yes.
Service complete, list the matter for admission on, what is the urgency? Okay. This is the matter for admission on 2nd of February 2026. In the meantime, the respondents shall bring on record their stand by filing the affidavit.
75 and 76.
Service, The registry shall certain as to whether the service is complete and thereupon list the matter. Yes.
Until 18.
For 18 years. Mr. Gogoi, you are going to get a 10,000 rupees today in view of a cost to be imposed upon the council.
I hope so.
Yeah.
As a year, when you got sick, right?
See, this is what happens when you don't see. And that is why I always tell the lawyer, wait for your turn. It means they have so many matters, they have so many responsibilities must be. When you saying that this old man is only waiting, sitting out there, we have a lot of other things to do. Anyways, issue notice making it returnable on 19th of January, 2025. Mr. R.R. Gogoi appears on behalf of all the respondents. Extra copies of the petition be served upon him by tomorrow. The case of the petitioner herein is that the petitioner have filed an application on 19/5/2025. Had filed an application on 16/5/2025 for the purpose of conversion of the IMFL on retail license to IMFL off retail license. The application of the petitioner have also been verified by respondent number 3.
4.
Respondent number 3 or 4?
Very good.
Respondent number 3. And thereupon, due recommendations have been made to the respondent number 2. However, the respondent number 2 have not taken into action any steps in that regard. The petitioner also had submitted a representation on 2/9/2025 to the respondent number 2. And the respondent number 2 thereafter also having not taken into account any action. Although it is the mandate of Rule 274A of the Assam Excise Rules 2016, the petitioner has approached this court by filing the present petition. The respondents are directed to bring on record their stand by filing the affidavit on or before the next date.
74, 79.
279A. Pendency of the incident with petition shall not, however, be a bar on the part of the respondent authorities to consider the application and take a decision. Yes, Mr. R. Bapujari. Anything? What?
Regarding item number 47, it's on 17, same one, one with them, I start proceeding.
Huh?
On 17, with my other file.
You want it on 16th?
Under 16 or 18.
16.
16, I am.
So you want to put the pressure again on me. I am not here on 15, 16. I had it on 17 because I can, but after that it becomes very difficult. So many matters. We'll have it after vacation. To item number Iman, to be listed on 21st of January. Mr. Bapujari, an interesting argument has taken place today in respect to one matter. The matter. See, right to file. Right to file. Filing of proceedings is a right to the litigant. And that is subject to consideration. Whereas, the power to entertain is not conferring a right upon the litigant.
Yes.
It's subscribed, the said power is such which is being conferred is subject to the formalities to be provided. Now, you see, section 166(3). Because today I was hearing the matter, I was in the midst of it, I was dictating it. Then one thing struck me. Section 166(3) says of the Motor Vehicles Act that no tribunal shall entertain an application after 6 months from the date of the occurrence of the incident. Now, there is no provision for condonation, nothing, but can 29(1) of the Limitation Act be incorporated, taking into account? Section 29(1) says that if a special law or a local law stipulates a period of limitation which is different from what is mentioned in the schedule to the Limitation Act, then section 3 would be applicable, as well as section 4 to 24. The reason is very specific. There's a very interesting aspect of section 29(1). By dint of section 29(1), the power to dismiss is also being conferred upon the authority upon an authority under the special or local law. Because here, section 3 says, no application so and so filed beyond the area shall be dismissed. So the power to dismissal in section 3 is conferred under 29(1) in the local laws and special laws.
And even the court has been brought with so much powers.
So that is against Sresnath. That is another aspect.
Then though it's not set up as a defense.
But that is another aspect. But 29 says that. It also gives, unless the special law statutes or the local statute do not bar application of section 4 to 24, which includes section 5. Now let us take the example of section 34(3) of the Arbitration Act. 34(3) says, person can file within 3 months, and under no circumstances it may be further condoned for another 1 month, but not beyond that. Meaning thereby, the stipulation which is there, the second part of section 29(1) is not being satisfied. So therefore, there is a prohibition by the special law not to incorporate section 5. This is what the Supreme Court held.
Even periodically, the philosophy finding that section 71 or 76 of the right to care compensation act.
Yes, they also.
That is, if it is there, then further limit, then they have to have it.
But this is a right to file, right to submit. You understand?
Yes, yes, sir.
But that is a right of the person concerned.
Yeah.
But it does not say anything about, and a power is being conferred under 29(1) by virtue of section 3 to dismiss. But when the Act categorically says you cannot entertain, means the power to entertain is being taken away. Can you imply 29(1)? I'm having it on next Tuesday, na? Tuesday, na?
Right.
At 10:30. Just find out and help me out. Because I'm going to look into it, but you see that nowadays we don't get so much time to research also. Just find it out if you. I've asked all the other councils out there, so I've half done it. This pertains to 166(3), whereby now after the 2019 amendment,
Yes.
they have incorporated that. Earlier 166(3) was there, but that was omitted by the legislature. Now, in view of various other things, they have brought in. But can this court say that you don't have the power or 29(1) cannot come in? Because in some cases, the court had exercised the power under section 5.
Yes.
Now, can section 5 be done? Can 29(1) be applied? Because the power of right to file, right to dismiss is another thing from the power to entertain.
But it is something like exercising a jurisdiction, if the power is not there, then how can I, madam, start the, something like that?
In a very, in something like of a very metaphor, you can very well put, I was telling them about the second appeal. The power to entertain the second appeal, a delayed second appeal, is not there.
It's not there.
It is subject to the condonation being there. And the condonation application being allowed. Now, the application to be dismissed is a power given under section 5 and section 3. That is another thing. But that is one aspect. That is right to file, right to dismiss. But to exercise powers under section 100, you have to frame the questions of law. How can you entertain without that? So this is just a type of a letter. So just think about it.
I'm so guilty of this.
Okay. I'll give you some homework. That is what I mean.